Hello and welcome everyone. I hope this message finds you fit and fine. We are in video number 42 in this Lakshmikant series, and today we are starting Supreme Court, one of the most important topic for prelims as well as mains. Let's start with the background of Supreme Court. Supreme Court is highest judicial court. We have a hierarchy in our judicial system: subordinate court at district level, then high court state level, then Supreme Court at union level. It is final court of appeal. If I say that president is the final court of appeal in India, and you read a news that this person has filed an appeal before president against a judgment which was given by Supreme Court, would you say that statement is true, that president is highest court of appeal? No, because president is not having court there. Okay, it's not like there will be an advocate who is going to have some discussion on behalf of you before president. Just file is going to be submitted before president. So president is not highest court of appeal. It is Supreme Court. Okay. It is highest constitutional court. What is the meaning of constitutional court? A court which is having power to interpret Indian constitution. And why we are saying highest? Do we have other courts having this power to interpret our constitution? Yes, we do. High courts. So high court and Supreme Court, they both have power to interpret our constitution, but highest is Supreme Court. If High Court has interpreted something and Supreme Court has interpreted another thing, after that, then whom we are going to support or going to obey? Supreme Court's interpretation, obviously, right? So India is single and unified judicial system, and there are three-tier structure, as I told you: subordinate, High Court and Supreme Court. Now let's start with the history, background of this word Supreme Court. So there was Regulating Act 1773. We discussed about this in historical background of Indian Constitution chapter, right? Within this law, for the first time, Supreme Court was established. Means that the provision was there, and then Supreme Court was established in Calcutta. But please remember that Supreme Court was different from the Supreme Court we are having now, okay? Because this was court of record with full power and function, but that function was not actually applicable to whole India, right? It was established to determine any suits actions for Bengal, Bihar and Odisha. Later, other Supreme Courts were also started. Yes, Supreme Court in Madras, Supreme Court in Bombay. So as of now, you know that there is one Supreme Court in Delhi, right? But there were other Supreme Courts which were established. 1800 Madras and 1823 Bombay. You need not to cram the facts, but you should know about the journey of this idea of Supreme Court in India. Then there was India High Courts Act. You should remember this particular fact because UPSC can frame a statement. A statement can be like this: Indian High Courts Act 1861 abolished Supreme Court at Calcutta, Madras and Bombay. Because I told you, separate Supreme Courts were established. 1773 as per that law in Calcutta, then 1800 Madras, then 1823 Bombay, right? So that was Regulating Act 1773, but it was actually established a year later, okay? Now the point is, as per this act, these Supreme Courts were actually revoked, okay? They were removed. And there was a time when these high courts were actually having this distinction of being the highest court, okay? But in Government of India Act 1935, from this particular law, we established federal court. Okay, now this federal court, you can actually now familiarize with the concept of Supreme Court which we are having now. It means now this federal court is going to be above these high courts. Okay, so please remember this particular fact. There can be a statement on this in your exam. Now, since one or two questions are asked like facts of, so we are having this question. When was the Supreme Court of India first inaugurated? It was in January 1950. Okay, so it's not like you need to cram all the dates. Okay, now constitutional provisions. Where is Supreme Court situated in our constitution? It is in part 5 chapter 6, the union judiciary. Okay, part 5 is union, and within that chapter 6 is union judiciary. Article 124 to article 147, we talk about Supreme Court. There we talk about its organization, jurisdiction, power, etc. Now, Indian Constitution under Article 124 subclause 1 says that there shall be a Supreme Court of India constituting of a Chief Justice of India, and until Parliament by law make some changes, there will be 7 other judges. Okay, not more than 7 other judges. But since it is saying Parliament by law can actually increase the strength of judges, that is why our Parliament has increased the number of judges. The jurisdiction of Supreme Court of India can be broadly categorized into original jurisdiction, appellate jurisdiction and writ jurisdiction. They are quite simple. We are going to understand them logically. Organization of Supreme Court. So as I told you, we have a hierarchy, right? We have subordinate court, district level. So if there is a metropolitan area, there also we are going to have 2 branches, civil and criminal. In district, we have 2 branches, civil and criminal. Criminal matters are dealt here. We also call it sessions court. Then we have High Court and then we have Supreme Court. Now I'm making a statement. You have to tell me the statement is true or false. I've not explained you this. Okay, I'm just asking you so that you can become a bit more curious. Supreme Court has supervisory, or you can say supervisory powers over district courts or subordinate courts. That statement is true or false? Come on. I've not explained you this. I just want you to attempt, because there's a rule in psychology. When you are going to attempt wrong and I'm going to say this is correct answer, then this is going to be retained in your mind. So attempt. What do you think? Supervisory role, supervisory power. Supreme Court over district court. Some of you might think, sir, Supreme Court is the topmost court and you just told us unified judiciary. So it means Supreme Court must be supervising district courts. That statement seems true, right? But reality is that statement is false, because district or session courts, these subordinate courts, they come under supervisory jurisdiction of High Court. Means High Court supervise their transfer, postings, right? So this is called supervisory work. Okay, it is not under Supreme Court. And why? Because everything is having logic in Indian polity. Why? Don't you think it is like adding burden to the Supreme Court's work if you give the supervisory work to Supreme Court? So many districts in India. Do you think it is logical? No. Now let's talk about strength. So as per Supreme Court number of judges bill, that it turned into act as well. Now the maximum strength can be 34. Okay. The Parliament is authorized to regulate them. Regulate what? Strength I'm talking about. Now let's talk about appointment of judges in Supreme Court. So judges are appointed by President, please remember. Okay. But the real twist is how. Because there's a debate there also. First we need to understand how it happens, then we are going to understand what is the debate there. Okay. So CJI is appointed by President after consultation with such other judges, judges of Supreme Court and High Court as he deems fit. Who deems fit? President deems fit. Okay. And is it really President using discretion? No. Council of Ministers headed by Prime Minister. So it means when it comes to CJI, President is going to appoint what this provision is saying, but President is going to take into consideration the consultation from Supreme Court judges, High Court judges. Okay. But how it actually happens, we are going to talk about it. I'm just talking about what provision is saying. The other judges are appointed by the President after consultation with CJI. Okay. And such other judges of Supreme Court, High Court as he deems fit. So it means in case of CJI, we are talking about consultation. In case of other judges, we are talking about consultation with CJI. Now, please remember that in general, there is a convention by which CJI is appointed. Convention is seniority. The senior most judge in Supreme Court is appointed as CJI by Honorable President. Although there is no law in this regard. That is why this convention has been broken in past as well. We are going to talk about it. But you need to be aware of these nitty-gritties. What is written in Constitution, what is not written in Constitution, what is convention, what is not. Okay. So appointment of Chief Justice from 1950 to 1973, the practice has been appoint the senior most judge of Supreme Court as the Chief Justice. So this was the practice till 1973. Then came the change. In 1973, Mr. A.N. Ray was appointed as CJI, superseding these 3 senior judges. Who did that? So Indira Gandhi ji was having government. As I told you, president has to act on aided advice of Council of Ministers, and this happened. Okay. Again in 1977, M.U. Beg was appointed the Chief Justice of India by superseding then senior most judge. Now this discretion of government, don't you think it is like influencing the judiciary? Don't you think it is against the principle of independence of judiciary? Some judges may try to actually give some judgment in favor of government in order to get this plum plastering. So this should not happen, right? So how this evolved? The discretion of government was curtailed by Supreme Court in second judge's case. So now Supreme Court actually pronounced judgment so that this concept of independence of judiciary can be actually protected, in which Supreme Court ruled that senior most judge of Supreme Court alone, please remember, alone, can be appointed to the office of CJI. So now it's not just a convention. Now senior most judge of Supreme Court is going to be appointed as CJI because Supreme Court made this judgment in second judge's case 1993. I think it is clear. Now, who among the following was the first woman judge of India? This is a factual question. Ms. Fatima Bibi, you should know about it. Which of the following statement is not true about India's Supreme Court? Not true, you have to tell. Okay. Article 124 to 147, Part 5 of Indian Constitution informs the composition and power of Supreme Court. Supreme Court was inaugurated on January 28, 1950. The first female CJI was from Karnataka. The statement is false. The reason is, till now, we did not had any female judge as CJI. Okay, but soon we are going to have in 2027. Okay, you have to mention the name in comment. Okay, this was in news. Judges of Supreme Court are appointed by President of India. So these three statements are correct. This is wrong, and you have to tell not true. Okay. Controversy or consultation. So first we talked about provision. Now controversy and how the system evolved. Now we are using the word collegium system. So this word collegium, what does it mean? It means who is going to be appointed as judge. Obviously is going to be decided by president, but someone has to give the name before president. Who is going to give that name? So now judiciary is going to give that name, obviously, because provision says consultation. So now this consultation is more organized now in the form of this collegium system. Supreme Court has given different interpretation of the word consultation. Now, as I told you, president should consult senior most judges of Supreme Court, High Court as he deems necessary, deems fit, right? So now this consultation, is it mandatory or it just advisory? So our constitution has not elaborated on that. So now what Supreme Court said? In first judge's case 1982, Supreme Court said actually this consultation is not mandatory. It means the court held that consultation does not mean concurrence and it only implies exchange of views. What does it mean? It means government, means Council of Ministers got more power than Supreme Court. Why I am saying that? Because Council of Ministers can advise President that we need not to listen to the consultation or advice given by this collegium or these group of judges. Okay, because consultation does not mean mandatory or concurrence, right? But later, in the second judge's case, 1993, the same judge's case which talked about this appointment of CJI based on seniority. Now, what it said about this consultation interpretation? The court reversed the earlier ruling and said, change the meaning of the word consultation to concurrence. Concurrence means no, president cannot appoint someone on his own. Means consultation, you have to concur with the consultation. So what does it mean? It means now Supreme Court. I'm using the word Supreme Court so that you can relate to the word judge. Okay, collegium. Okay, although in this collegium there can be High Court judges as well. Okay, so now means power, or you can say ball came in the court of judges, right? In the third judge's case 1998, the court opined that consultation process to be adopted by Chief Justice of India requires consultation of plurality. Now, what does it mean? As I told you, in the second judge's case, one thing was clear, that the recommendation or consultation of this judges, it is mandatory. You have to concur with that. You cannot actually randomly pick and choose anyone as judge who is not actually given this recommendation by these group of judges, okay, whom we are calling collegium. But now the point was, in this collegium there is CJI and the other judges. So what if CJI is recommending one thing and other judges were actually not agreeing with that? Whom we are going to consider consultation as concurrence? CJI's authority or CJI's recommendation will be superior than others. So on this third judge's case said that no, CJI requires consultation with plurality. And what is the meaning of plurality? It means CJI should consult other judges as well. And if other judges, for example, more than 2 judges are saying no, we are not agreeing with the name, then CJI cannot recommend that person's name to the president that please appoint that person as Supreme Court or High Court judge. The sole opinion of CJI does not constitute consultation process. This is third judge's case. He should consult a collegium of 4 senior. Now, after this third judge's case, the word collegium, its structure became more clearer. He should consult collegium of 4 senior most judges of Supreme Court, and even if 2 judges give adverse opinion, as I told you, if 2 judges are saying no, we should not actually recommend this person as Supreme Court judge, then CJI should not send recommendation. And even if CJI send recommendation, then government, or you can say Council of Minister advising president, they can actually say no, we are not going to concur with this, because consultation equal to concurrence is only when CJI consult with the other judges as well, right? And in this consultation, more than 2 should not actually disagree. So that is why recommendation made by Chief Justice of India without complying with the norm, this is the norm, required consultation process are not binding on government. That won't be binding. Clear? Now lawmakers and contestation. Now there has been this debate that collegium system is opaque. Many times, see some senior most judges of Supreme Court and High Court, their son and daughter, they also are recommended by collegium, whereas there are many other first generation judges as well, but they don't get due chance. These are kind of allegations. So it means this opaqueness should be removed. On this, NJAC was actually introduced by Parliament. So they amended the constitution and they brought this NJAC, National Judicial Appointment Commission. And in this NJAC, I think it is visible to you, in this composition, they also added Union Law Minister. So it was CJI, 2 senior most Supreme Court judges, Union Law Minister, and 2 eminent persons. So now, judiciary said no, you are adding 2 eminent persons, you are adding Union Law Minister. It is like executive is having say in deciding who is going to be judge in Supreme Court. So judiciary said this is against the principle of independence of judiciary, and that is why this NJAC was declared null and void. So this idea of bringing transparency in this appointment of Supreme Court judges, this was declared null and void. So now we don't have any NJAC system in India. But since it was a part of debate, that's why I've brought up here. This PDF will be shared in my Telegram group, Shashank Tyagi for you. You can pick up from there. If you have any doubt whatsoever, you can shoot me a message on shashank.powerbean. That is my Insta handle. A person to be appointed as judge of Supreme Court, what qualifications that person should have? That person should be citizen of India, number 1. Apart from this is a mandatory. Now, from these 3, so there should be at least one condition which should be met. That person should be judge of High Court or High Court for 5 years. Okay, you should be judge of High Court for 5 years. If you're not judge of High Court for 5 years, you should have actually followed the second condition. He should have been an advocate of High Court or High Court in succession for 10 years. Okay, advocate in High Court for 10 years. Even if you are not fulfilling this condition, then you have third option. He should be a distinguished jurist in the opinion of President. President should declare, oh, this person is a legal luminary. That person is a legal researcher and that person has contributed in our law making process or interpretation of law in India. So on this basis, you can also be considered for this position of judge, right, in Supreme Court. Now the Constitution has not prescribed minimum age. Please remember, Constitution has not prescribed any minimum age for the judge of Supreme Court. Okay. But these conditions are such that themselves actually make sure that only a person who has achieved this much feat is going to be there. So it is going to take some time. Now oath and affirmation. So it is given by President. Tenure of judges. So there's no time limit. There's no 5-year, 6-year tenure to the Supreme Court judges. What happens? they can be in this position for the maximum time of 65 years. If you are appointed at 62, it means you have 3 years remaining. If you are appointed at 60, then you have 5 years remaining. He can resign office by writing to the president. So president gives the oath and you can write resignation to the president. He can be removed from your office by president on the recommendation of parliament. So there is a process there. How removal happens? UPSC has asked question in prelims. So this is the stage. Number 1. So if you want to start this removal process of Supreme Court, High Court judge, you should actually have at least support of 100 members in case of Lok Sabha, 50 members in case of Rajya Sabha. Consider you have a letter on which 100 members have supported. Now you need to present this letter before Lok Sabha speaker. If you are in Rajya Sabha, you need to take a sign of 50 members saying, no sir, we have some proof against this particular judge. We want this removal of judge. So this matter need to be referred to chairman of Rajya Sabha. After that, if speaker chairman accepted, please remember the word is if, means there's a possibility. You have the sign of 100 members and you have presented before Speaker Lok Sabha, sir, we want removal of this Supreme Court judge. It may be possible that speaker says, no, I'm not agreeing, I'm not accepting your recommendation to actually start this removal process. So that is why if word is used. Please remember, UPSC play these kind of tricks. Then if they accept, a speaker or chairman, whichever house you are taking up in, then 3-member committee will be constituted who is going to investigate the charges. Committee investigate the charges and they are going to see whether that person is guilty of incapacity or misbehavior. And if they found, now the process of impeachment is going to start. Although some book says that impeachment word should be used for the removal process of president only, there are other books which also use this impeachment word for the removal of Supreme Court, High Court judges. So point is, after this committee has investigated, found the charges valid, then this process is going to start. Then motion must be passed by special majority in the first house. Then this particular motion will be presented to the other house, and other house also it need to be passed by special majority. Okay, and when it is passed by both houses, then motion is presented before president. As president signs on this, then it is considered that this judge is removed. As of now, in our history of independent India, no judge has been removed by this process. Okay, no impeachment happened. Now we have a question relating to this particular subtopic. Just attempt. Consider the following statements. You have to answer which statements are correct. The Judges Inquiry Act 1968 regulates the procedure relating to impeachment of judge. The president can issue the removal order only after an address by parliament has been presented to him in the same session for the removal. Same session. It means, consider this process started in, say, winter session. Okay, and it was passed from Lok Sabha, but somehow when it was presented to Rajya Sabha, it could not be taken up, and then session actually ended. Now can Rajya Sabha take up the same motion in the next session and get it passed and then get it presented to president, and president sign, and that person will be considered removed, that judge will be considered removed? Or you need to get it passed in the same session. If it is a monsoon session, get it passed from the both houses in the same session. If it is not passed from the same session, then you have to start it again. Okay, so this is the meaning of the second statement. Now the address must be supported by absolute majority of each house. As I told you, it is a special majority. It's not absolute majority. The statement is wrong. So far, 2 judges have been failed to impeach, and 1 impeached in Supreme Court of India. This statement is wrong. I've just told you no one has been impeached till now. So it means 1 and 2 statements are correct. It means A is the answer. Clear? So this is the explanation. This will be available in your PDF. Acting Chief Justice. What is the meaning of this? Consider, Chief Justice of India has vacated office. It may be resignation, death, or removal. Then you need acting Chief Justice. Who is going to appoint acting Chief Justice? Who is going to appoint? President. Please remember, President. Chief Justice of India is temporarily absent. For example, Chief Justice of India is on, say, on medical treatment, that he's in coma or something. So in this case also we need acting Chief Justice, right? President is going to appoint. Chief Justice of India is unable to perform duties. It may be possible. So in this case also, President has to appoint acting Chief Justice. Then we have ad hoc. Ad hoc means temporary. Consider, we need a bench. Bench means in Supreme Court, decision on a particular judgment is not taken by one judge. There's a bench of 3, 5, etc. So there's a shortage of judges at that point of time, and one bench is having just 2 judges and we need one more. So temporary arrangement can be done. When there's lack of quorum, we call it quorum, means minimum strength which is required. For example, 3. Then, and because there's shortage of permanent judges. So in this case, Chief Justice of India can appoint a judge of High Court, as ad hoc judge in Supreme Court for a temporary period. Ad hoc means temporary. But for this, you need to actually consult with the Chief Justice of that High Court, because you are giving additional work to a judge of High Court, right? So you need to take permission, consult with that Chief Justice of that High Court. Consult word needs to be used, and you need to take permission. You need to keep into, you can say, loop President of India. So after consultation with the Chief Justice and concern with the President. So Chief Justice of that High Court and President should be kept in loop. Then only CJI can appoint a High Court judge as ad hoc judge in Supreme Court. I think this trajectory is clear to you. Judge so appointed should be qualified for the appointment of Supreme Court judge. For example, that if a High Court judge, if a person got a position of High Court judge six months back, can that person be appointed as ad hoc judge? No. At least you should be qualified for becoming Supreme Court judge. For example, in the appointment criteria, what I told you, in case of High Court judge, you need to be High Court judge for at least 5 years, right? So a question can be actually played at this point. Judge so appointed attend the sittings of the Supreme Court in priority to the other duties of his office. While so attending, enjoys all the jurisdiction, power, privileges during discharging his duty as Supreme Court judge. Now retired judges, can they be actually taken into job again for temporary period? Yes, there's a scope. CJI can request a retiring judge of Supreme Court or retired judge that we have a shortage of judges and we need your work, your contribution. So at this point, that person can also be given some position. He can do so only with the previous consent of the President and also with the person to be appointed. So President should be kept in loop. Now procedure of court. So what does it mean? Means how actually court work, what kind of judgments or what kind of powers it is having. For example, Supreme Court wants some new rules. So can Supreme Court make its own rules? Yes, Supreme Court can make own rules or own procedures, but in this case, approval needs to be taken from President. Okay. Constitutional cases or references to the President under Article 143, we are going to talk about it. The purpose is that there are certain procedures. For example, all the cases are usually decided by bench consisting of not less than 3 judges. Okay. When there is a case of advisory jurisdiction, President has referred a matter that need to be taken up by 5 judges. As I told you, 3, 5, right? So odd numbers are the numbers of judges on a bench on Supreme Court. Why not even? Why not 4, 6? Because there will be a tie, right? If there's odd, so majority, actually the support of the majority is going to decide the judgment of Supreme Court from that bench, and that is why odd numbers are taken in the Supreme Court benches, not the even ones. Now Constitution has made following provisions to safeguard and assure independence of judiciary. So what are the points? For example, mode of appointment. In mode of appointment, judiciary has a say, concurrence, consultation, security of tenure. You cannot remove Supreme Court judges arbitrarily. There's a process, we just talked about it. Fixed service conditions, Parliament cannot change them when that person is already a judge. Expenses charged on Consulate Fund of India. It means you cannot vote again and again every year how much you need to give to the Supreme Court judges as salary or pension. You cannot do that. Conduct of judges cannot be discussed. Okay, charge on Consulate Fund of India, I told you about in Parliament chapter as well. It means this much amount need to be given and this will be given. Okay, you need not to vote it during the budget. Right? Conduct of judges cannot be discussed in Parliament until unless there's a removal motion which is in place. Okay, so that you can uphold the dignity of this court. Ban on practice after retirement. You cannot practice as an advocate after retirement, so that there's a transparency there. Power to punish for its contempt. If someone does not obey, or you can say attempt to you can say demonize, or you can say spread such news which hampers the dignity of the court, then such contempt can be leveled. I hope you remember there's a case of Mr. Prashant Bhushan, advocate in Supreme Court. There was a contempt court which was going on. Freedom to appoint its staff, its jurisdiction cannot be curtailed, and separation from executive. So these are the, you can say, provisions which make sure that Supreme Court can work in independent manner. Now, these are the important sections within Supreme Court. Original jurisdiction, advice jurisdiction. Supreme Court is a court of record. It means decisions binding on other courts, as a court of record, as well as highest court of appeal, as well as writ jurisdiction. So these are the jurisdictions of Supreme Court. We are going to talk about them in a step-by-step manner. Okay. First of all, original jurisdiction. It simply means the matter can be taken up at the level of Supreme Court directly. For example, if there is a matter between center and state, center versus state, if they are having dispute, they can take up directly towards Supreme Court. If there is a dispute center plus state versus some other state, original jurisdiction. Third case, state versus state, original jurisdiction. Means these disputes can be taken up directly to the Supreme Court. That is why they are called original jurisdiction. But there is another word, exclusive original jurisdiction. What does it mean? It means matters which can be taken up only at the level of Supreme Court, only. So let's attempt this question. Then we are going to expand it further. Consider the following statements. Matters referred to Finance Commission, interstate water disputes, dispute arising on any of treaty agreement, certain expenses, dispute arising of any pre-constitutional treaty agreement. Which of these does not come under original jurisdiction of Supreme Court? What does it mean? It means matters which cannot be taken up directly at the level of Supreme Court. I hope you remember our discussion in center-state relations. I talked about, for example, interstate water disputes. What our constitution says, there will be a tribunal, right? And the decision taken by tribunal will be final, right? This need not to be taken up at the level of Supreme Court. You cannot take up this matter directly to the Supreme Court because there is a tribunal. So our constitution says that, right? So now I hope you are relating. It means this matter is not going to come under original jurisdiction. So there's a list. Original jurisdiction of Supreme Court does not extend to the following cases. I hope this is visible to you. Let me zoom in a bit. For example, if there is a dispute related to some interpretation on pre-constitution treaty. What is pre-constitution treaty? A treaty which was signed during Britishers' time. Yes, they are applicable even now. So if there is a dispute, okay, for example, there is a dispute on a pre-constitutional treaty between Kerala and Tamil Nadu regarding Mullaperiyar Dam. So that is pre-constitutional treaty example. Agreement, covenant, sanad and other instruments. So they are not coming under original jurisdiction. It is not they are going to be directly taken up at the level of Supreme Court. Any dispute arising out of any treaty, etc., specified, specifically if that treaty is providing this matter will be taken up by this jurisdiction, said jurisdiction. It may be tribunal, right? Interstate water disputes can be taken up tribunal, right? Matters referred to Finance Commission. Adjustment of certain expenses, pension between center and states. Ordinary dispute between of commercial nature between center state. Recovery of damages of a state against center. When I say they are not coming under original jurisdiction, it means they cannot be taken up directly at the level of Supreme Court. When I say exclusive original jurisdiction, it means this matter need to be taken up directly at the level of Supreme Court. Okay. Now, let me give you one other example so that this becomes much more clearer to you. Take example of writ. Writ issued by Supreme Court related to protection of fundamental right. Okay. Tell me, if a statement is being asked by UPSC, that writs for protection of fundamental right, they come under exclusive original jurisdiction of Supreme Court. That statement would be true or false? That statement would be false. You know why? Exclusive nahi. That is original, means can be taken up directly at the level of Supreme Court, but not exclusive. Why? Because this writ can be taken up by using Article 226 at the level of High Court as well. By using Article 32, it can be taken up at the level of Supreme Court. So it means it will be considered under writ jurisdiction as well as original jurisdiction of Supreme Court. Can be taken up directly at the level of Supreme Court, but not exclusive original jurisdiction. Okay, because why not exclusive? Because it can be taken up at the level of High Court as well. I think it is clear now. So writ jurisdiction. Supreme Court is empowered to issue writs including habeas corpus, quo warranto, certiorari. We discussed about them. In this regard, Supreme Court has original jurisdiction, as I told you, explained already. Can go directly to the Supreme Court. However, writ jurisdiction of the Supreme Court is not exclusive, already explained. High Court are also empowered to the issue such writs. That is what I have explained this to you, right? If I say writ jurisdiction of High Court is much more elaborate than writ jurisdiction of Supreme Court, that statement would be true or false? Come on. Statement would be true. You know why? Because High Court's writ jurisdiction, High Court can issue writ for fundamental rights as well as legal rights. But in case of Supreme Court, as per Article 32, Supreme Court is empowered to issue writ for protection of your fundamental rights only. Okay? Now attempt this question. Which of the following statement is not true? You have to identify not true. Supreme Courts can issue writs that relate with only fundamental rights of citizens. High Courts can issue writs on issues that relate with fundamental rights as well as other reasons. The jurisdiction with regard to writs is wider for the High Court as compared to Supreme Court of India. Writ jurisdiction of Supreme Court can be extended by Parliament but never decreased. All statements are correct. Parliament cannot decrease, but Parliament can increase writ jurisdiction, right, of Supreme Court. Clear? Appellate jurisdiction. The word comes from the word appeal. If you're not satisfied with the judgment of High Court, you can go to the Supreme Court, right? So appellate in which cases? In constitutional matters, means it is related to interpretation of constitution by High Court. For example, in case of this IPC section 377, I'm talking about homosexuality. So that matter was appealed from Delhi High Court to Supreme Court because that was an appeal in constitutional nature, because some people said it is against Article 21, right? Means right to life and personal liberty. Matter related to civil matter, appeal related to criminal matter, appeal related to special leave. What is special leave? Can anyone tell me? In comments. So special leave means, for example, High Court. So if High Court has pronounced a judgment and you're not satisfied with the decision of High Court, you can actually appeal to Supreme Court, right? But there's a process there. If you want to appeal to Supreme Court, you want to use this appellate jurisdiction of Supreme Court, you need a certificate from High Court. If High Court thinks that your case is not worthy to be sent to Supreme Court, and High Court is not issuing you the certificate on the basis of which you can appeal in Supreme Court, then what you consider? Means doors are shut in Supreme Court for you? No. So in this case, you can use the special leave, as the word says special leave. In this case, you will present an affidavit before Supreme Court saying, sir, I have not got permission from High Court, I have not got the certificate, but I want my case to be actually heard at your level. So in this case, the Supreme Court Secretariat is going to decide whether to accept your special leave petition or not, whether to accept your case or not. Means discretion is with Supreme Court whether to accept or not. But if certificate is issued, then Supreme Court has to accept. Supreme Court has to at least listen once. Okay. So I think it is clear now. Advisory jurisdiction. As the name suggests, advisory. So as per Article 143, President can seek advice from Supreme Court on two matters. One, if there is a matter of urgent public importance arising which is likely to arise, or any dispute arising of pre-constitutional treaty, agreement, covenant, engagement, etc. In this case, there is also a twist. Twist is, in case of advisory jurisdiction, Supreme Court is bound to give advice to the Honorable President in the second case. but not bound to give advice to Honorable President in the first case. You would say, oh, such thing can happen. Yeah, this happens. And there's a logic behind it. Consider the case of Babri Masjid. So before the final judgment by Supreme Court, this was a matter, urgent, important matter, right? There was a huge debate going on. In this case, if President use Article 143 and seek advice from Supreme Court, what's your opinion? What should happen in this case? Then Supreme Court can say, sir, though it's a matter of public importance, but we are not going to give you advice because matter is already under sub judice. And if we give you our advice and it becomes public, it means the judgment is already done. Why wasting arguments there, right? We cannot put the matter out till we actually listen to all the arguments. That is why we are unable to give you such advice. But in second case, you are bound to give advice. Now my question to you, as per advice jurisdiction, the advice given by Supreme Court to the Honorable President is binding on Honorable President. It is true or false? Answer is false. It is not binding. It is just an advice. So advice given is not binding on President. Clear? Court of record. It simply means the decisions which you take are going to set legal precedents and legal references by the other courts. Okay, means other courts, means high courts and other courts are going to refer your judgment, and on this basis they are going to pronounce their judgment. High Court and Supreme Court both are court of records in India. Okay, it has power to punish for contempt of court as well. Power to judicial review. Our Supreme Court can judicially review our legislative action, executive action. They are going to see whether it is in consonance with the provisions of Indian Constitution or not. If not, then this can be declared ultra vires or null and void. Judicial review. As the word suggests, judicial review means power of judiciary to review actions of legislature and executive. As you know, our political system is having three pillars. Legislature is there to make law, executive is there to implement law, and judiciary is there to adjudicate the conflicts, right, to resolve the conflict by pronouncing judgment. So this concept of judicial review is giving power, some additional power to judiciary to keep a check over legislature and executive, that they should perform their duties as per Indian Constitution. Although this is the concept, but UPSC is going to play on the depth, on some intricacies, some details. So we are going to cover those details as well. So this concept was originated in USA, specifically in this case, Marbury versus Madison case. Mr. John Marshall was Chief Justice of American Supreme Court, who actually contributed in evolution of this concept. So by now, you are clear about the basic idea of this judicial review. Our Supreme Court says that judicial review is part of basic structure of Indian Constitution. What does it mean? It means that our Parliament cannot take away this power from judiciary by even amending our Constitution. So a protection layer is actually given to this concept. Such is the importance of this concept. Okay, and in what case actually, in which case this particular concept was given the status of basic structure? Indira Gandhi versus Raj Narayan case. Okay, so judicial review gives power to judiciary, right? Now, even though we have in India principle of separation of power, principle of separation of power evolved from ideas of Mr. Montesquieu, who said that too much power concentrated in one pillar will turn this pillar as tyrant. That is why these three crucial functions should be separated in three pillars. So he was talking about separation of power among these three pillars, right? But don't you think this concept of judicial review gives power to judiciary to intervene in the functioning of other pillars, right? And that is why some sections, some legal luminaries have said sometimes the judicial review actually becomes judicial overlapping. Okay, we are going to talk about it further. So as of now, you should know that even though we have in India the principle of separation of power of the three arms of the state, namely executive, legislative, judiciary, clear to you? Judiciary is vested with the power to review over actions of other two arms. This is what I have explained to you. Now, consider a law has been made and this law is taking away some of your fundamental rights. This law is against some of the basic principles of Indian Constitution. Now, the point is how judiciary is going to act. If all the laws which are made through our parliament are submitted before Supreme Court so that they can be reviewed and then they will be implemented, is this the practice? No. Now, how judiciary came to know that this particular concept is against fundamental rights or is against some of the features of Indian Constitution? How does it work actually? So for that we should know suo motu cases. Suo motu means on its own. It may be possible that government has released this particular act and this act has been covered in media and as well as this gazette notification, which is like the official newspaper of government. And some of our judges in Supreme Court or High Court, they have read some of the provisions which are published in gazette. And they came to know, oh, these provisions are against this particular part of Indian Constitution. These provisions are going to take away these fundamental rights of people. So in this case, Supreme Court can act suo motu as well. Suo motu means on its own. Even if none of you go to Supreme Court against this particular law, Supreme Court will act for your protection. That is called suo motu cognizance. Okay? And second is PIL, Public Interest Litigation. It may be possible that some of you consider yourself good Samaritan. You consider that, oh, we are preparing for UPSC and we understand what are the implications of particular law are going to be. So you have read and you found that this is against Constitution. So you can actually file a PIL in Supreme Court or any High Court, wherever you are, right? In this case, now court can actually take up this case, okay? And it may be possible the particular law is abridging fundamental rights of a tribal community, okay? And you are not from tribal community. So court is not going to say, if you are not from tribal community, your fundamental rights are not being abridged, why you have come here? Court cannot say that. Why? Because this condition has been relaxed, that discontinuation of the principle of loco standi. Means it is not necessary that you should be the person who is being implicated or you are the true sufferer, okay? Anyone can file this public interest litigation. The word itself says public interest. You file this litigation for public interest, okay? So then judiciary can actually do the review work. Now, Justice Syed Shah Muhammad Qadri has classified the judicial review into 3 categories. What are? Number 1, judicial review to actually keep a check over constitutional amendment. For example, a constitutional amendment is against fundamental right, is against any provision of constitution, then it can be, that judicial review can be used, okay? Second, judicial review can be used against some legislative action of parliament or state legislature. Means they have not amended constitution. It is plainly a law which is made by parliament or any state legislature, but if it is against the spirit of constitution, then also judicial review can be used. And third is executive action. It means if some administrative action, for example, you are a district magistrate and your action is against the spirit of constitution, your circular is against the spirit of constitution, then it can also be taken up under judicial review and your action can be reviewed, and if it is found against constitutional spirit, then it, or constitutional provision, then it can be declared null and void. Okay, so you need to remember 3 ways, okay? Constitutional amendment, legislative and executive. Clear? Now, Supreme Court has used this power in number of cases. For example, Golaknath case, bank nationalization case, Privy abolition case, Kesanand Bharti case, the minimum mill case. Do you remember about NJC discussion which we were having in the Supreme Court lecture? I told you that Supreme Court declared NJAC as null and void, which was supposed to replace this collegium system. So how Supreme Court did that? Supreme Court did that by using this power of judicial review, right? Supreme Court said it is against the independence of judiciary, and independence of judiciary is basic structure of Indian Constitution. Now, importance. What is the importance of judicial review? So you can remember these points. Number 1, it actually upholds the supremacy of Constitution. This country should be run as per Constitution, and who is going to ensure that? Judiciary can ensure that, but judiciary needs some tool, some power, some weapon, and that weapon is judicial review. Then, to actually keep a check if executive is turning into a tyrant, right? To actually balance the federalism. What does it mean? It means, you know that our constitution has certain features which give some more power to center, right? For integrity, for ensuring integrity of India, right? But state might say, sir, this is against federalism. Center is abusing its power and taking away our power. So in this case, who can actually come into picture for balancing this by balancing this federalism? So this can be done by judiciary. Okay. UPSC even asked this question last year in prelims regarding federalism, and one of the statement was related to this, right? So you should remember, means independence of judiciary is also important for ensuring federalism in India. This should be a statement in your mind. Now, it is essential to keep a check on legislature, as we discussed, for securing independence of judiciary, right? For example, this case NJC, and for actually protecting your rights. For example, Article 32, Article 226. Our High Court and Supreme Court can actually issue writs for protection of your rights, right? And they can also review any law which is taking away your fundamental rights. So these are the, you can say, importance of judicial review. Clear? Now, constitution provisions for judicial review. Now we are going to go article wise, and some of these articles we have already discussed, but still I want to go with you article wise. Article 13. Remember fundamental right discussion. So Article 13 says that any law that is inconsistent with or derogation of fundamental rights, means any law which has been made which take away any of your fundamental rights, means provisions mentioned in part 3, then it will be declared null and void. So our constitution frameworks have not mentioned the word judicial review, but they have clearly given this you can say space to judiciary to act in this regard. Okay. Article 32 regarding fundamental rights, Supreme Court issue writs. Article 131 original jurisdiction, we discussed it, right? Just told you now, center state, right? In the previous session we discussed interstate. So interstate, center state, any kind of dispute can be taken up at the level of Supreme Court as per original jurisdiction. 132 appellate jurisdiction means a matter which you have not satisfied with, which has been already been pronounced, say at level of High Court, you can take up this matter at level of Supreme Court. 133 provide appellate jurisdiction to Supreme Court. 134 appellate jurisdiction in case of criminal. So it means civil and criminal. So 132, 133, 134, they're talking about appellate jurisdiction. Okay. You may be thinking, sir, how they're related to judicial review? These we have discussed in our Supreme Court chapter as well. So my friends, we are discussing judiciary, right? And the way judiciary can act. For example, a case has been lost in Supreme Court through appellate jurisdiction. Okay. Within that case, a matter has been raised in which judiciary need to review a particular law. So judiciary can review that particular law, but how that case actually came to judiciary? Through appeal. First, that case was, for example, a case was related to a law made by state. So first that case was discussed at level of High Court, then it came to Supreme Court, right? So these are the ways by which judiciary can actually do the review. Article 134A, certificate of appeal. I hope you remember, in High Court, if judgment has been pronounced and you are not satisfied, you can go to Supreme Court. For that, High Court is going to issue you a certificate. If you are not given the certificate, High Court is saying, no, you don't waste the time of Supreme Court. Then also you can go to Supreme Court, but for that, what you need to file a special leave petition, SLP, right? We discussed it. 135, empower the Supreme Court to exercise jurisdiction power in pre-constitutional law. I gave you example of Mullaperiyar Dam. I hope you remember, Travancore state, Madras state, right? So they were having this treaty. Now Kerala and Tamil Nadu government are actually coordinating this Mullaperiyar Dam on the basis of a treaty which was signed before constitution, right? And in that case, if there was, say, any issue, then federal court was there. Government of India Act 1935. So our constitution is saying that later the function of federal court will be taken up by Supreme Court. 136 authorizes Supreme Court to grant special leave petition. Now please remember, consider you were charged in a criminal case, okay, and you were given life imprisonment. Now you want to file a case in Supreme Court, appeal, but High Court is saying no, you should not go, okay. But now you can go to Supreme Court using SLP, special leave petition. But now Supreme Court Secretariat is going to actually keep a check over the affidavits you have submitted, and it is their prerogative whether to accept your case or not. But please remember, SLP is not available to military tribunals and court martial. For example, you were serving in Indian Army, you were a major, and you were charged on some indiscipline which you have created. Now, the judgment which has been pronounced by court martial, if you are not satisfied, so you can go to AFT, Armed Forces Tribunal. You can actually move further. But if High Court, you can go to High Court later. But if High Court has pronounced the judgment and High Court said, no, I am not going to issue certificate to you to go to Supreme Court, then you cannot go to Supreme Court. Because SLP way, special leave petition way is not available in case of court martial. Please remember that, since it is an exception case, that is why I am saying there can be a question on this point. Okay, I hope it is clear to you now. Article 143 authorizes President to seek opinion. I hope you remember advice jurisdiction. And in advice jurisdiction, I gave you 2 points, right? There were 2 ways, right, on which President actually seek advice of Supreme Court. And I also told you in which case it is binding on Supreme Court to give the advice, right? Article 226, we are talking about High Court to issue writs, and I told you about that High Court's power to issue writs is elaborate than Supreme Court, right? Because High Court can issue writs for protection of fundamental rights as well as legal rights. Article 227 vests High Court the power of superintendence. I told you about that High Court is having supervisory jurisdiction, means supervisory power over these district courts. I told you about this logic in the start of Supreme Court chapter. So we are revising here. 245 deals with territorial extent of the laws, means if a law has been made by state legislature, till what extent this law will be applicable. 246 deals with matter of laws made by parliament, by legislature states, for example, union list, conference list, and state list. Article 251 to 54 provides conflict between, in case of conflict between central law, state law, in case of conference list, whose law is going to prevail? Central law is going to prevail. We discussed it. Article 372 deals with continuation, for example, pre-constitutional treaty, Mulla-Periyar Treaty. So it is continuing, right? Pre-constitutional law is continuing. There are many pre-constitutional laws. For example, our whole IPC, CRPC. So for example, Indian Penal Code. So it's a pre-constitutional law. But don't you think it is continuing? It is the basis of giving punishment, right? So this is continuing as per Article 372. Now, scope of judicial review. There are 3 grounds. Number 1, FR. Means in which way this judicial review can be used. So if FR, fundamental rights, are taken away, in that case judicial review. It is if it is outside the competence of the authority which has made the law. For example, consider a law has been made and that is not taking away any of your fundamental rights, and that is also not against constitution. Can judicial review be used here? Can there be a scope there? Yes. Because the authority which should be responsible has not actually made the law. For example, you know that a state can make law on matters mentioned in state list and concurrent list. If state legislature has made a law on a matter which is mentioned in union list, now tell me, don't you think it can be struck down by using judicial review? Yes. Why? Because it is also against constitution, right? So this is the second scope. I hope it is clear to you by this example. Repugnant to the constitutional provision, if any law is against any constitutional provision, then it can be considered as a scope of judicial review. Okay, I hope it is clear to you now. Now, judicial review and 9th schedule. So there is an interesting twist in our constitution which happened during the time of our first Prime Minister, Mr. Jawaharlal Nehru. So what he did, So he wanted to make these land reforms. For example, prohibition of zamindari, lensing laws, etc. But at that point of time, right to property was fundamental right. So there was this fear, if law has been made, that's a good law, right, for ensuring socio-economic justice. But the point is, many people who are going to lose their land, they're going to file case in Supreme Court and High Court saying our fundamental right is abridged. And Supreme Court, High Court may say that since it is against fundamental right, we are declaring your law, the law which is made by Parliament, as null and void. To protect the sanctity of this law, they wanted some tools, so they wanted some change in our constitution. So they made this Article 31B. So what 31B is saying? That any law which is added in 9th schedule. So in our original constitution, there were 8 schedules. So 9th schedule was added. Schedule means a list which is added at the end of constitution. So in the end of the constitution, there is a list which was added. And this Article 31B is saying any law which is added by a government in this 9th schedule of Indian Constitution, then it will be considered to be, you can say, beyond judicial review. So if means Article 13, judicial review power won't be applicable on any law which is mentioned in Schedule 9, right? So I hope you understood what it was, why it was made, right? So originally 1951, 9th schedule contained 13 acts and now it is more than 280. Of these acts and regulations, the state, so purpose is land reforms, abolition of zamindari system. Zamindari system, there's a farmer, there's a middleman. Zamindar was responsible to collect the taxes and pay to Britishers. So it is under this taxation policy of Britishers. Now, in a significant judgment, IR Coelho case, Supreme Court said this is not going to continue. Means if you are saying any law which is added in 9th schedule is beyond judicial review, then this particular precedent can be misused. Fundamental rights of people can be taken away. As of now, you have given the logic that we are doing this for good of poor, farmers. Understood. But a legal precedent can be misused by any government in future. So judicial review cannot be restricted by this mere adding of 9th schedule. And that is why this IR Coelho's case said that judicial review will be applicable even in the case of 9th schedule. Okay. The court held that judicial review as a basic structure, basic feature for Indian Constitution, it cannot be taken away. And it also said the laws which were added after 24th April 1973, they can be challenged even if they are mentioned in 9th schedule. The laws which were added before, means before this date 24th April 1973, they will remain there. There is no need of challenge in that case. So Kesavan Bharti case was the reason of this date, because Kesavan Bharti case said basic structure doctrine is going to be applicable. Now these are some examples of amendments. So in order to cram these or date, just attempt the questions here. Which one of the following statements regarding the exercise of judicial review is not correct? You have to tell not correct. A case must be brought before the Supreme Court regarding the validity of a law. Do you think it is true or false? It is true, right? But you have to identify not correct. Unanimous opinion of all the judges is necessary for declaring a law null and void. This is false. Because I told you in the Supreme Court chapter that decision by Supreme Court bench is taken on the basis of majority. If there's a 5-judge bench, if 3 are saying we are in favor of this, then that is going to happen. Legislative enactments, executive orders may be struck down by Supreme Court. It is correct, although we got the answer. The power is implicit in the provision of Article 3. Implicit. Please remember, if UPSC make another statement and says explicit, then that statement would be wrong, because the word judicial review is not mentioned in Article 30. Now the next question. Which one of the following is correct? The power of judicial review means the power of Supreme Court to set aside any. Now please read the statements in detail, because some statements would be close to correct, right? But we have to identify the correct one. thus set aside any executive decision if it is against statutory law. Tell me, do you think judicial review is there to keep a check on subsequent laws, whether they are in consonance with the law which is made by legislature? No. In judicial review, our focus is on constitutionality, not any law, right? Set aside any provision of law if it is contrary to fundamental rights. It is correct. But it is saying set aside any provision of law. Now tell me, judicial review is used just to set aside a provision in law, or it can actually struck down the whole law. It can struck down the whole law. Now on this point, I hope you remember, also talked about the doctrine of severability, doctrine of eclipse when we were talking about fundamental rights. And I told you that sometimes UPSC makes statements in which two statements seem to be correct. But we have to identify which is more correct, right? Which is actually exactly correcting to the statement which is mentioned in question. Examine constitutional validity of any administrative action as well as legislative provision. Strike it down if not found in accordance with the constitutional provision. Now read this question statement. The power of judicial review means the power of Supreme Court. Remember, many students are going to commit this mistake. The second statement also seems to be true, because this can happen. If there is a law and this law is having, say, 10 provisions, and 2 provisions are against fundamental rights. So we talked about this doctrine of stability, doctrine of eclipse when we were talking about fundamental rights. So it means can set aside any provision of law, right? But in this question statement, the word is review means. The power of judicial review means. So do you think it means just that, or it means third statement? It means third statement. This is the actual meaning. And since this is the actual meaning, that is why the statement is correct. This is the answer. Okay. So by this, what I want to convey, in prelims exam, sometimes 2 statements may be correct. But we need to identify which is correct answer. So answer to judicial review means is this. Okay. Review its own decisions or decisions of any court tribunal. This is incorrect. Okay. This is not judicial review, right? To review its own decision. I hope it is clear. Now, judicial review in the Indian Constitution is based on procedure established by law. Why? Because it is saying in the Indian Constitution. So our Indian Constitution mentions procedure established by law, although at least later stage our judiciary adopted this doctrine of due process of law from US Constitution. So we adopted that, right? But mention when we talk about procedure established by law. The jurisdiction of Supreme Court of India may be enlarged by Parliament by law. I mentioned this when I was talking about Supreme Court. Judicial activism. The word simply means that judiciary is going to work as an activist. It means for larger good of society, judiciary may sideline the set precedents. Here the word precedent represents the boundaries which are set by doctrine of separation of power. As you know, legislature is there to make law, executive to implement law, and judiciary to adjudicate, to resolve conflict. Now, if legislature loses confidence of the people, means not making laws which people need. Executive loses confidence due to poor administration. Now, can there be a stable system if people are not having confidence in these 2 important pillars? No. Now, what choice judiciary has? To remain in boundary or to step up? What you suggest? I think you would say, sir, judiciary should step up in this situation, if situation is such at least, right? So in this case, when judiciary step up, then we call it judicial activism. Judiciary may pronounce some judgments which are actually considered as encroachment into the work of legislature or executive. Okay. Now this term was first coined in USA. There was one article, The Supreme Court 1947 Fortune magazine. Although this term actually got applied in India in 1970s, and there is a specific reason to that. Because first 2 decades after India's independence, Congress was having huge legitimacy in the eyes of people. And that phase of India's judiciary is considered as pacifist phase. Judiciary was agreeing with what executive was saying. But then things changed. Let's start with one question. Who among the following is associated with judicial activism in India? Answer is all 3 judges. Now, meaning of judicial activism, you should remember, judicial activism is there for protection and expansion of individual rights. Protection and expansion. And for that, judiciary depart from the set precedents, as I told you, established patterns. And sometimes it is considered that it is like intrusion into the legislative or executive matters, right? So these 3 key points you should remember. Now just attempt this question. Which of the following is an outcome of judicial activism? Please remember, question is not saying which of the following is related to judicial activism. It is saying outcome. If it says related, then answer would be different. Outcome. Judicial review, public interest litigation. Answer is public interest litigation. Because the public interest litigation is actually manifestation of judicial activism. Clear? Judicial review we discussed in the previous video. Now, the concept of judicial activism, and as I told you, that if it is saying related, then answer would be different. Because judicial review is also used for judicial activism. But it is saying outcome of judicial activism. Outcome is not judicial review, right? The concept of judicial activism is closely related to concept of PIL, as I told you. PIL is like a tool, one tool of judicial activism. Apart from the reasons which I have just mentioned, like failure of legislature or executive, there are others as well. For example, judicial enthusiasm. It means judges like to participate in the social reforms. It encourages the public interest litigation, and it happens due to the relaxation of principle of locus standi. It means even if you're not party to that particular case, but for larger public interest, you can take up this matter before judiciary. You can take example that when it comes to some social evils in our society, so legislature is there to make law regarding this, that these evils are prohibited and this is going to be punishment. But if there's a situation that legislature is not doing anything in this regard, and someone actually filed a PIL in court, so now judiciary can actually use the judicial enthusiasm and be part of social reform. Judiciary can prohibit by its decree that this social evil is prohibited, right, and punishable. Then legislative vacuum, it is connected to this. It means if legislature has not made the law and there is a requirement, then judiciary can step up. The Constitution of India has also given enough scope for judiciary to actually work in this manner, means to legislate on these important matters. When I say legislate, it means it's not like judiciary is actually making an official law, bill, no. For example, the judgment of Supreme Court, because Supreme Court is court of record, has power that it is going to be applied as a precedent, right, by other courts as well. Now, activators of judicial activism. According to Mr. Upendra Bakshi, we can categorize them in these following headings. 1. Civil right activist. It means there may be some activists who are demanding some civil and political rights. So this is one section where judiciary work as judicial activism, use activism. Then people right activist. Here we talk about socio-economic reforms. For example, there's a PIL for, say, farmers. Farmers not getting their due. Payments not given to farmers for their sugar cane, which they have already given to some sugar mills. So judiciary can actually intervene here, although this function is of executive. But for the larger good of society, these poor farmers, judiciary can intervene there. And it will be considered as an economic right. Consumer right groups. For example, judiciary is saying that these particular brands has to give this detail. These details should be published before you present this product to any consumer, right? It means labeling, etc. Any law regarding this, it will come under consumer right groups. Citizens for environmental action. In past few years, if you have seen, especially with regard to the pollution in Delhi NCR. Our Supreme Court has acted, in a wide variety of manner, right? Supreme Court has established a dedicated commission who actually also coordinate with Delhi, Haryana, Punjab, specifically on this matter of pollution near Diwali, right? So environmental action, rights of child groups. As you know, that child are the least represented group of a democracy because they don't have the age, they don't have the say, right, vote. So in this regard, judiciary has intervened. So if activists bring this point to judiciary and judiciary work in this regard, this is one section. Then women rights groups, for example, Vishaka guideline, for example, judiciary interpreting sexual harassment laws, assorted lawyers. It may be possible that some dedicated influential lawyers, they also influence the point of view of judiciary on a particular important matter. Now, judicial activism versus judicial restraint, there are two words, activism and restraint. And these are opposite words. Restraint word itself represents that judiciary is setting a limit on its own action. This judicial restraint word has been used by our former CJI also, for example, Mr. R.M. Lodha. In his farewell party, he was saying that judiciary should use judicial restraint moreover and judicial activism rarely. Now, what is this? In judicial activism, judiciary loosely interpret constitution. Loosely, it means judiciary actually increases increases its power by interpreting constitution. But when it comes to judicial restraint, it is a strict interpretation. It means believe judges should follow the precedent. So when judges follow the precedent, it is judicial restraint. When they set aside precedent for the larger good, that is judicial activism. Now, assumptions of judicial restraint. So now we are going to talk about assumptions which are used in USA. Okay. So in case of USA, and this is very much applicable everywhere, that they say that judiciary should actually use judicial restraint, not judicial activism, because judiciary is not an elected body, right? In democracy, faith of the people is in parliament, legislature, and thereby executive, right? So undemocratic, non-elective, non-responsive to the people. That is why they should not encroach upon, into the powers of legislative and executive. Origin is also, discussed that it is questionable, not specifically granted by the constitution. The way it is acting means activism is not granted by the constitution. It is due to the loose interpretation of judiciary that judiciary has given itself this power. Doctrine of separation of power is being compromised due to this. Concept of federalism. Take example of USA. When it comes to federal and state, they have different laws. It may be possible that federal law is totally different on that particular topic and state law is different. And you know that concept of federalism is quite strong in case of USA in comparison to India. So dividing the powers between the nation and the states require the court deference. Means court should also uphold this. Means court should not actually intervene into the state government and its officials. Non-ideological but pragmatic assumption that since court is dependent on the Congress, we are talking about US, House of Representatives, because court is dependent on Congress for its resources, right? So in this manner, that court should actually limit its power because they are also dependent on House of Representatives, on public acceptance for its effectiveness, not to overstep its boundaries, right? So this particular point is based on this fact that law is based on reason, and reason represents reason of people, faith of people. When people accept you, then only you can be effective. So judiciary should not surpass that boundary. Then being a court of law, custodian Anglo-American legal tradition, law being a process of reason and judgment. So it represents that legal precedents are also having social context, and judiciary should also take into consideration this. It is not like if some courts in the world are using the judicial activism in this manner, so you also do this interpretation in context of your country. Now, it was of USA, assumptions which USA has with regard to this. Now, what our Supreme Court has observed. Now just see, Supreme Court has said that judicial restraint should be used. Judicial restraint and ask courts to take over the functions of legislature, or should not take over the function of legislation and executive, should not encroach into this. So it is with concern to the bench that they should uphold this particular principle. Because if they encroach into legislature executive, then it actually gives an image that the system is not balanced. And if judiciary is getting strong and legislature or executive are getting weak, this is not good for country. Some people may say what we want is good. If judiciary is doing that, then what is the harm? There's a harm. Because if a law is there which is made by legislature and you're not happy with that, you can change that particular party in the next election, right? You can give them a message, but same cannot happen with regard to court, right? And if you don't follow the decision of court, then it actually is a question on legitimacy of court. That is why balance is necessary. Trying to perform executive and legislative functions is clearly unconstitutional. Constitution has not said that you perform legislative and executive function. And on this point, you can also remember, consider the example of coal scam. In coal scam case, Supreme Court actually, in coal scam as well as in this telecom scam, this 2G spectrum scam, court by its judgment said we are actually cancelling these licenses. So cancellation of license could have been an executive action by the respective ministry, but court did that. Now, a point on this is that court is not well versed with the market dynamics. Court is not well versed with the ground reality, because court is not having department working on ground, but executive has. So executive has more experience, practical experience. That is why if court perform such actions, it may be having some ramifications in that actual market or on the ground. That is why it is unconstitutional to work in this manner. Judicial activism must not become judicial adventurism. It should not be like an adventurism. Restraint should be there, and minimization of judge preferences. Mean there should be some standards which need to be upheld by every judge. It should not be an adventurism. Judges must know their limits and must not try to run the government, because running government is not your job. They must have modesty and humility. They should not work as an emperor. Now, judicial restraint is actually complementary to the balance of power concept. There should be balance of power. Judicial restraint not only recognizes the equality of other two branches, means legislative and executive. These are the positive points of judicial restraint. It also fosters that equality by minimizing inter-branch interference in the judiciary. Because if you interfere in legislative executive, then it may be possible in future they will intervene. So it is also a threat. It may also turn into a threat to this independence of judiciary concept. So judicial restraint tend to actually protect independence of the judiciary. So if they set their limits, then other will also set their limit. This is how practically system is acting. Now let's attempt this question. In recent time, judicial activism comes in news frequently. Judicial activism can be said in action in which of the following cases? Legislature executive wings of the government fail to discharge their duties under Constitution, Supreme Court intervenes. It is correct. This is the basic definition. High Court intervenes through appeal against the judgment of lower court. No. Here, judiciary is taking appeal from the lower court. This is not correct. A court monitors the development in a case during the period and issues necessary direction. It is also correct. So it means answer is 1 and 3. It means C is correct. PIL, public interest litigation. In previous class, I mentioned that PIL is a manifestation of judicial activism. I hope you remember, right? Now, what is PIL actually? Let's divide this word into two parts. One is litigation. Consider you are having dispute with someone and your private interests are being compromised, and that is why you file a litigation in court. The core of your litigation is your own private interest. You cannot call it public interest litigation. But there's a second case. You're filing a litigation for poor. You're filing a litigation for rights of some ethnic religious minorities. You are filing a case in court for the interest of consumers. Now, focus is not just you. Focus is a section. Focus is interest, general interest of public, right? So that is why we can call now the second case, the second litigation as public interest litigation, right? And why public interest litigation is important? My friends, you know that every person living in our society is not aware about his, her rights, right? Even if some people, some sections are aware, they're not having enough resources. They don't know the way so that they can actually ensure their rights are protected. So that is why we need some good Samaritans, people who know the way, right? So they can file petition on their behalf. That is why PIL is important. This concept actually developed in USA, and purpose was to give legal representation to underrepresented, unrepresented sections like poor, consumers, like I gave example, environmentalists, etc. Legal representation. What does it mean? You know that our nation works on law, means constitution is the fundamental law, right? And constitution has given certain rights. Constitution has also given certain obligations to the state, means government authorities. And if they are not doing their job well, don't you think there should be something in this regard? And how can we ensure such action? So judicial activism becomes important in this particular scenario. And that is why in previous class I told you, when legislative or executive branch fails to fulfill their responsibility, then judicial activism becomes a necessity. In case of India, Mr. V.R. Krishna Iyer and Mr. P.N. Bhagwati, Justice P.N. Bhagwati, they were regarded as the people who forged this idea of PIL in Indian context. Apart from word PIL, we have other names as well. Social action litigation, social interest litigation, class action litigation. Okay. So these are actually other names of PIL. Now, what is the meaning of PIL? You have understood the meaning? To summarize it, PIL constitutes a legal action initiated in court, right? You have filed the litigation. It means legal action initiated in court. And the purpose is for safeguarding general interest, right? Not just your private interest. Now, this PIL as a concept was defined in which case? It was SP Gupta versus Union of India case. Please remember, UPSC can ask a direct factual kind of question as well as UPSC can make a statement. Okay, one statement would be on the case in which it was defined, and other statement would be on condition, or you can say guideline with respect to PIL. Okay. So real purpose of PIL is to ensure rule of law. This nation should be run with law, right? No one is above law. Second, access to justice to these poor people, or you can say socially or economically poor people. Then meaningful realization of fundamental rights. So it means you need to remember 3 points: rule of law, access to justice, fundamental rights. For these, PIL becomes important, right? Now, public interest litigation in India is to be linked with what? Come on. It's like a basic question. Judicial activism, I've just told you, right? PIL is a tool or manifestation of judicial activism. Feature of PIL. Number one, it is like a strategic arm for legal aid movement. Legal aid movement. As I told you, some people are not having enough legal representation, lack of knowledge, lack of awareness. Even if they are aware, they don't have enough resources, they don't understand the way. So that is why PIL becomes a legal aid movement, giving legal support to these people. It is different from other litigations. As I told you, there can be private litigation as well. Example number one. Example number two was public interest litigation. PIL brought before court with the intention to promote and vindication of public interest. Purpose is public interest. Constitutional legal rights need to be protected. This remains a focus of PIL, right? PIL is essentially cooperative effect. So what is cooperative? When PIL is being filed, you should not consider that this is other litigation. In other litigation, there may be two warring parties who are engaging in conflict. But the idea of PIL is that court is doing its duty, the person who has filed PIL is doing his or her duty, and state is going to perform his or her duty. Means government is going to perform their own duty. So it means when all three work in tandem, then only you can actually do the work which is needed. So that is why PIL is essentially a cooperative effort. Now, purpose is to ensuring public duty. Means if government has not done something, then government should do that. Protecting social, collective, diffuse rights, interest, right? Now, there's another point here. There's a difference between public and private, right? So public interest litigation is not going to pronounce judgment in lieu of some individual right? Purpose is to talk about what are the rights of public and what has not been done and what should be done now. Such directions are given. Now, which one of the following case Supreme Court gave direction to end child labor? So it was Bandhua Mukti Morcha versus Union of India. Again, I am saying this is factual, but UPSC can ask question by multiple statement. One statement is going to be. Now, scope of PIL. In what cases PIL can be filed? So, Supreme Court has given some guidelines with regard to this, and these guidelines have modified in time also. One is bonded labor. It means your PIL can be on the basis of bonded labor. Second, if labor laws are not being implemented in letter and spirit by some employer, then in that case, there can be a case of PIL. Second, jail. It means if basic human rights are being abridged in jail, it may be for speedy trial for fundamental right. So, the petitions from jail can be considered of one case of PIL. Again, petition against police, not filing FIR, harassment by police, judicial, you can say death in custody, right? So these are the cases of, you can say, PIL on the basis of police, against police. Petition against atrocities of women, against women. You must have heard about this, that there was no law before Vishaka guidelines were pronounced by Supreme Court with regard to sexual harassment of women at workplace. So it means issue was there. In India, we have skewed sex ratio in our jobs. Women are less in number in formal sector. And one reason is sexual harassment at workplace, right? No effective law in that regard. So in this case, Supreme Court actually pronounced the judgment. And later, Sexual Harassment of Women at Workplace Act 2013 came into play, right? So these petitions become important. Then it may be a petition on the basis of for rights of SCs, STs, or economically weaker section, economically backward classes. Petition for environment or family or pension, etc. Now, in which court PIL can be filed? It can be filed in High Court as well as Supreme Court. So answer is both. Principles of PIL. For Supreme Court, High Court, they can exercise their power under Article 32, Article 226 in this regard. Means any interested person can file this PIL for disadvantaged section. If court found that there has been serious gaps when it comes to protection of fundamental rights or state not performing constitutional duties, in this regard also, court can even accept your PIL via letter or telegram. If court found that large section of people, there has been some injustice. For example, in case of rights, there were allegations that district administration acted in biased manner. In this case, court can invoke these provisions under Article 14, Article 21, equality before law, right to life and personal liberty. If court found that yes, violation of constitutional right of a group of people happened, in this case, it may not allow the state or government from raising the question as to maintainability of the petition. The state cannot say that we are raising our voice against maintainability of this petition. It is not worthy to be discussed. Court will say, we will decide whether it is worthy or not you. Because this petition is going to have implication against your functioning. It is going to bring gaps in your functioning. Dispute between two warring groups purely in realm of private law would not be allowed to be agitated as PIL. But please understand, UPSC can play here. A statement can be made, dispute between two warring groups and a litigation in this regard cannot be considered as PIL. Tell me, the second statement which I have just said is true or false? It is false. Because it may be possible a litigation between two warring groups may have some orientation, may have some angle of public interest. If this is the case, then it can be considered as PIL. But if only it is focused on private motive, then it won't be considered as PIL. Court in special situation may appoint commission also to investigate. Court would ordinarily not step out of the known areas of judicial review. High Court though may pass an order for doing complete justice to the parties. Now let me explain what is complete justice here. And in case of Supreme Court Article 142, UPSC in prelims has actually made one question specifically on this. It may be possible that state means legislature or executive, they have not made a law in a particular area. And some people are getting impacted due to this. Now, court, when pronouncing judgment, may issue a decree which may have power of law, which is going to have power of law. So, in this case, for giving complete justice, court can act in this manner. For example, Vishaka Guidelines case, I mentioned, right? Sexual harassment of women at workplace. So, this law came way later in 2013, but Vishaka Guidelines came earlier. So, this is point number 7. Now, guidelines for admitting PIL. PIL is not a pill or panacea. I mean, it is not the ultimate solution for all the wrongs which we are observing in our system, right? It was essentially meant to protect basic human rights of the weak and disadvantaged. It is just a way so that we can actually work, but it is not like now every other branch should actually lay their arms, okay, PIL is there. No. Public spirited person file a petition before the court for poverty, helplessness, economic, social disabilities, and there have been recent times increasingly instances of abuse of PIL. So now our topic of discussion is abuse of PIL. When people use PIL just to actually, you can say, add hurdle to the working of some other person. It may be government functionary. So Supreme Court laid the following guidelines for checking the misuse of the PIL. So it may be against private person also, it may be against industries, it may be against government. So it is said that some people are actually doing this as a profession. First they file PIL, when they create some legal hurdles against other person, then they will take money from that person, and that's how they settle the matter. So it means precious time of judiciary is being misused by these faulty PILs, right? And judiciary is well aware of this, and that is why they have issued guidelines. Encourage genuine and bona fide PIL. Bona fide PIL means on affidavit you accept, yeah, this is the truth. If it is found that you have, there has been mismatch in what you said and what is the reality, and you knew that, so then action can be leveled against you. The court should prima facie verify the credentials of the petitioner also. Instead of every individual judge devising his own procedure for dealing with PIL, it would be appropriate if court itself actually standardize this process. Means court should accept PILs in an orderly manner, and high priority should be given on larger public interest, urgency and gravity issues. Court, before entertaining PIL, must aim at redressal of genuine public harm and public injury. No personal gain, private motive should be there. Court should also ensure that petition filed by busybodies or extraneous or ulterior motives should not be actually given chance as well as discouraged. So when I say discourage, it means fine can be a way of discouraging such PILs. Which one of the following will not be entertained as PIL? Come on. Petitions of early hearing, case pending in High Court, obviously it is not going to be. So it means not. So it means this is the answer. You cannot file a PIL that my case is pending and please actually give me an early date. Although riot, neglected children, forest and wildlife, these all can be considered as cases of PIL. So UPSC has consistently asked questions on Nalsa, Lok Adalat, Gram Nyayalas, but students take these topics lightly. Their major focus is on Supreme Court and High Court when it comes to the judiciary, and maybe on certain key, you can say, events or judgments, that's it. But you have to clear the exam. This is a competition, right? Your strategy should be fine-tuned. So let's start subordinate courts and give attention to the details, because devil is in the detail. And I'm also going to mark Q, means question, from where question may be asked. Subordinate court are mentioned in part 6 of Indian Constitution, Article 233 to 237. So why we are using the word subordinate courts? In the previous sessions, I've told you that we have integrated judiciary, Supreme Court, High Court, then subordinate court. At district level and below that also we have certain courts. So we call them subordinate courts, right? Now, appointment of district judges, appointment. And please understand, UPSC can play with you by saying in one statement appointment of judges at district level and appointment of district judge. So there's a difference between the two, right? Because judges at district level can be other judges as well. For example, additional district judge, metropolitan magistrate, right? So you need to give attention to the district judge, okay? So appointment, posting, promotion of district judge in a state done by governor of the state in consultation with High Court. Now tell me, have I mentioned SPSC here? No. So who is appointing? Governor is appointing in consultation with High Court. So primary role is with High Court actually, right? Have we mentioned a state government here? No, we have not mentioned state government here, right? So primary power is in hand of High Court, right? A person to be appointed as district judge should have the following qualifications. Qualifications are not already be in the service, whether central government and state government. You cannot be part of government and you simultaneously will say, sir, please appoint me as district judge. Okay. He should have been an advocate or a pleader for 7 years. He should be recommended by the High Court for appointment. Recommended by the High Court for appointment. Obviously, should be citizen of India. Now, appointment of other judges, and there's a difference here, right? Judges in subordinate judiciary means at the level of district court or below that. Okay. Appointment of person other than district judges to judicial service of a state are made by governor. Appointment is made by governor, but process is different, right? After consultation with SPSC means State Public Service Commission and the High Court. So in case of judges at the level of district, the question can be asked on difference. So difference is SPSC. I hope now you're not going to make the mistake. Now control over subordinate court. So High Court has the control, right? And district judge at the level of district is having prime responsibility, right? The control over district court and other subordinate court, including the posting, promotion, leave, person belonging to judicial service of the state. So all these functions lie with High Court. I hope you remember in the previous session, when we were discussing High Court, I told you about supervisory jurisdiction. And in the Supreme Court chapter, I asked one question, whether Supreme Court has supervisory jurisdiction over subordinate court or not. So answer was no. You cannot say, sir, it is the apex court. Why we are not saying that supervisory jurisdiction of Supreme Court extends to district court? There are so many districts. Do you want to burden Supreme Court more? Right? That is why the supervisory jurisdiction of subordinate court lie with only High Court. Now structure and jurisdiction. So this is the structure. Please look at this side, means civil court and criminal court. Here we have revenue court, where when you are going to become civil servant, you will have role here. Now civil court, district judge or district session judge, sub judge, family court, municipal court, small causes court. Criminal court, we say sessions court. District session judge, metropolitan magistrate or first class magistrate, second class magistrate, third class magistrate. And in revenue court, we have board of revenue, commissioner or collector, tehsildar, naib tehsildar. Sub collector means sub-divisional magistrate also have say in case of revenue court. There's a revenue court of sub-divisional magistrate also, SDM, right? But we are focusing here. Okay. Now, district judge is also called a session judge. Although district judge is having responsibility with respect to civil as well as session matters. Okay. When I say sessions, it means criminal nature. When I say civil, it means we are talking about civil nature. Civil Procedure Code is going to be applied. In case of sessions, IPC, right? Indian Penal Code is going to be applied, or you can say referred. He is the highest judicial authority in the district. Now, he possesses original and appellate jurisdiction. There can be a question from here. So, original jurisdiction, what does it mean? It means cases of civil nature or criminal nature can come before district judge, okay, in first instance. So this is called original jurisdiction. But appellate means can come via appeal, and appeal can come only from lower court. Now some of you might be thinking, sir, this is district judge, and he is also having, or she is also having, this position is also having appellate jurisdiction. Yes, just take a look. So we have below the status, we have other courts as well, na? So judgment can be appealed here. Okay, so both is there, means original as well as appellate. Okay, original as well as appellate, and criminal matter as well as civil matter. Okay, there can be a question. He exercises the judicial and administrative power. Now judicial power, you know, when he is acting like a judge, and administrative power include the management of staff in the judiciary at the level of district or below that. Okay, that is administrative function. the way files are going to be processed, the way cases are going to be taken up, the way court fees is going to be accumulated, right? That is administrative function. He also has supervisory power over all subordinate district court. This is we have discussed. Appeals against the orders and judgments of district judge lies at the level of High Court, because above district judge there is only one stop, that is High Court, right? I hope these things are clear to you now. The session judge has the power to impose any sentence, including life imprisonment. Capital imprisonment means death sentence, okay? But in case of death sentence, I told you in the High Court part, death sentence cannot be executed till that death sentence is reviewed by High Court of that state, whether that person who has received death sentence, you can say appeal or not, okay? A capital punishment passed by him subject to confirmation by High Court, okay, whether there is an appeal or not, right? I hope you will remember that. Twice we have discussed it. Now, let's talk about NALSA, National Legal Service Authority. First question which I should ask from you is, what is the utility of NALSA? Why there is NALSA? What NALSA do? What is the status of NALSA? Since we are saying it's an authority, is it a constitutional authority? Is it mentioned in constitution? Or it is a statutory authority, means mentioned in a law made by parliament? What is its status? Or it is a executive authority, means not mentioned in constitution, and neither we have a law made by parliament in this regard. This was made just by executive resolution of the cabinet. What do you think? What is the status? Come on, answer. I can actually directly teach you, but why I ask in this way? Because there's a rule in psychology. When you are going to commit mistake and you get the right answer, there's high probability you're not going to forget that, and that's our purpose. Now, Article 39A, do you remember? Free legal aid, DPSPs, we discussed it, right? So it was a constitutional promise, right? It was a direction to the state that whenever you make policies, when you are having resources, you should actually make efforts to give free legal aid. Because if you have created, so many courts, but having justice is a costly affair, then how can a poor person actually attain justice? Then if poor person is not able to attain justice because that person is not having money, then don't you think it is injustice in itself? System is not allowing that person to take services of court, right? So that is why we created NALSA, okay? Of the Constitution of India, free legal aid in poor weaker sections. Article 14, equality before law. So it should not be like now that if someone is rich, that person has committed murder. Now the father of that person who got murdered is not able to actually file a case because that person is not having money. So don't you think this would be equality? This would be against the principle of equality before law, as well as equal protection of law. So that is why we needed NALSA. Along with this, Article 22, subclause 1, if you remember. For example, if you are being arrested, then you should be told reason why you are being arrested by the police. So if you are being arrested arbitrarily, so you can only come out if that police is having kripa over you, or other ways that you have an advocate taking stand for you before magistrate. So you need an advocate, and if you don't have money, how you are going to come out? That is why we needed some authority, and that's why NALSA was created through an act of parliament. If it is created by an act of parliament, what is the answer? Answer is statutory body, okay? Legal Service Act enacted 9 November 1995. NALSA has been constituted under this act, means statutory body, to monitor and evaluate. Now, please remember the functions, objectives. Okay, UPSC has asked question on NALSA on this aspect. What NALSA do actually? Monitor and evaluate implementation of legal aid program. Can you actually tell me some legal aid program which was recently in news? Means a program by government for providing legal aid to the poor people. Can you name some program, scheme of government, initiative? Fast. Think. No? Search about telelaw. What is telelaw? What government is providing in this? How this telelaw facility is going to be provided? What is the role of CSCs here, common service centers? Should be aware of this. Okay. In every state, a state legal service authority, in every high court legal service committee have been constituted. Okay. District legal service authorities, taluk legal service committees have been constituted in district and most of the taluks. Taluks, you know, blocks, to give effect to the policies and directions of the NALSA. Now, why these are being created? Now, you should not think that these are bodies totally independent of NALSA. Some students have these kind of misconceptions. But read this line. Means these bodies were created so that the purpose of NALSA can be fulfilled. Right? To give effect to the policies and directions of NALSA. Directions. What is directions? UPSC will play on these points. Okay? Now, provide free legal aid service to the people. Now, one statement which UPSC can play with you is that Lok Adalats were also created as per this Legal Service Authority Act. Now, what you are going to think? Question is from Lok Adalat, but UPSC is linking Legal Service Authority Act and Lok Adalat. Come on, what's your guess? Some of you might think, sir, Lok Adalat seems different. It is Adalat. And this NALSA is actually providing free legal aid, means advocates, court fee, documentation work. But Lok Adalat is a proper Adalat. So how can these two be connected? But the reality, my friend, is that they are connected from the same law. And that is why this is a trap question, where many students are going to be trapped, but you should not. Okay. So we are going to elaborate it further. NALSA lays down policies, principles, guidelines, frames, economical for the state legal service authorities to implement legal service programs throughout the country. Primarily state legal service authorities, district legal service authorities, taluk legal service committees, etc. have been asked to discharge the following functions, and functions are these three functions. First, free and competent legal service. Free and competent legal service. Who is going to provide legal service? Advocates, right? Free of cost advocates. Second, to organize Lok Adalats or for amicable settlement of disputes, means without fighting the case in the formal court, you can resolve that case peacefully in Lok Adalat. So Lok Adalat is also connected with the same law, right? Now, to organize legal awareness campaign. So you got three primary you can say ways in which this NALSA system work. Now, free legal service include, what is included? One is court fee, second is lawyer, and third is documentation. Documentation during the proceeding of the case. Along with this, if you need to file an appeal. So in both the cases, because documentation, affidavit, all of them need, money to be paid. So this will be taken care of by NALSA or these legal service authorities. So I hope you will remember these keywords, right? Court fee, lawyer, and documentation, and it would be quite easy for you now, right? Now, Lok Adalats. So Lok Adalats is a forum. So first of all, what is the meaning of the word Lok Adalat? Lok means public, Adalat means court, means it's a public court. And actually it is different from the conventional court because the working of Lok Adalat is flexible. Right? It is flexible and it is made so that your matter can be resolved in a speedy way, right? And it is bit of informal as well, which is pending in, because you know that a lot of cases are pending in all the courts, and that is why Lok Adalat actually can actually working as a cushion to resolve these pending cases. Not yet brought before up. Now there is a scope of question from here. Okay, read this. And I am going to also show a question which was asked from here. Lok Adalat is a forum where the cases or disputes which are pending in a court or which are pre-litigation stage, not yet brought before the court, are compromised or settled in an amicable manner. So two aspects are written here. One is pending, or those which are in pre-litigation stage, means case has not started yet. The case has been just filed. Okay, in both the cases, matter can be taken up in Lok Adalat, right? Please remember it, because in UPSC, one statement is going to be made that only pre-litigation cases can be taken up in Lok Adalat. That would be wrong. Okay. Now the word Lok Adalat means people court based on Gandhian principle. Remember, is one of the components of alternative dispute redressal mechanism or system. Means rather than going in long litigations and expensive litigations, resolve the disputes out of the court. As Indian courts are overburdened with backlog of cases and regular courts are to be decided that involving lengthy, expensive and tedious. So that is why it's a resolution process. Now statutory status. First of all, Lok Adalat is the executive body or statutory body. I told you, statutory body, right? Institution of Lok Adalat was given statutory status under Legal Service Authority Act 1987. That is why I was saying NALSA and Lok Adalat are linked to the same law, right? I hope it is clear. Now, Act was provision related to organization and functioning of Lok Adalat. The State Legal Service Authority or District Service Legal Service Authority, Supreme Court Legal Service Committee. So at the level of Supreme Court, High Court, we have these committees for the same purpose. They have advocates to actually support, give free legal aid. High Court Legal Service Committee, Taluk Legal Service Committee may organize Lok Adalat. So who can organize Lok Adalat? This can be a question. At what stage it means Lok Adalat is going to be, you can say, organized. So this is my understanding that many students, when they read about Lok Adalat, they have this notion in mind, oh, we are talking about Lok Adalat. So they must be actually organized at the level of, say, subdivision, village, right? That's some mental picture many students have in this mind, right? So that is why if UPSC play on this point, many students would say, oh, it means Taluk Legal Service Authority or District Legal Service Authority. They should be the one who are going to organize these Lok Adalats. Why would actually these High Court based committees or Supreme Court based committees organize? So this is where there will be a trap. Okay. So if you are gaining from these series and you are actually this way of actually make you understand these things, if you are gaining from this method, do let me know in comments, or you can share with your friends as well. Now, every Lok Adalat organized for an area shall consist of such number of serving or retired judicial officers. Generally, a Lok Adalat consists of a judicial officer as chairman. Judicial officer as a chairman. There can be a question from here from composition point of view. A lawyer, advocate and a social worker as member. Alright. So, composition also include lawyer or social worker. Social worker is also there. Okay. Now, any case pending before the court can be referred to the Lok Adalat for settlement if the parties thereof agree that yes, we want to go to Lok Adalat, or any one party actually apply that we want to go to Lok Adalat, or court itself actually found that this case is actually fit for Lok Adalat, means is appropriate to transfer Lok Adalat. So, in any of these cases, matter can be referred to Lok Adalat. Okay, and if someone has actually paid a court fee, and now court has said your matter is quite simple, why don't you go to Lok Adalat? So when your matter has gone to Lok Adalat and that has been resolved there amicably, then your court fee is also going to be refunded. Lok Adalat shall have the same power as vested in civil court while trying to in these matters. So what does it mean? It means enforcing the attendance of any witness, means witness is the keyword should know, discovery and production of any document, reception of evidence on affidavit, the acquisition of any public record or document, such matters may be presented. So it means for actually, while taking decision, what a judge require? It requires some proof, arguments, witness, documents. So all of them can be actually used in Lok Adalat as well. Okay, Lok Adalat has these powers. All proceedings before a Lok Adalat shall be deemed to be judicial proceedings with the meaning of Indian Penal Code also. So it means criminal nature cases are also going to be taken up, right? And every Lok Adalat shall be deemed to be a civil court for the purpose of Code of Criminal Procedures. Benefits of Lok Adalat: court fee can be actually refunded, speedy trial hai, flexible hai. There is no strict application of procedures like CPC, CRPC, means concept of natural justice can be used. The parties to the dispute directly interact and judge through their counsel, which is not possible in court of law. Means you have a counsel and you can directly interact with the judge. The award by Lok Adalat is binding on the parties and the status of decree of a civil court, and it's non-appealable. Once UPSC asks question from here, non-appealable, what does it mean? And why non-appealable? Don't you think it can be injustice also? Means a matter has been decided in Lok Adalat and you want to appeal in further, you cannot appeal. Why? Because in Lok Adalat, it is not like judge is pronouncing a judgment. So in Lok Adalat, method uses alternative dispute redressal. It means both parties will actually agree. They will shake hands. Okay, we are settling on this. And the Lok Adalat will sign the order that both parties have agreed on these conditions. It means resolved. So if both parties have agreed in Lok Adalat, why you want to waste the time of court further? Now if you ask, sir, if there is no scope of appeal, yes, there is a scope. And the scope is, if one of the parties says that I am illiterate or I was not of sound mind when such sign or such signatures were taken from me. On this basis, appeal can be done. Legal Service Authorities Act 1987 also talks about having permanent Lok Adalat. What does it mean? There may be certain cases related to public utilities. For that, there can be a permanent Lok Adalat. District judge or additional judge or held judicial higher rank, means above this additional district judge, can actually be part of that composition. Chairman would be district judge or ADJ or anyone above this rank. Now, what is public utility we are talking about? If there is dispute related to transport service, air, road, water, postal, telegraph, telephone service, supply of power, light, water, so these are public utilities, right? Permanent Lok Adalat shall exercise jurisdiction in respect to more public services. Now, you must be aware of this fact. If not, then listen to this. Majority of litigations which are pending in court, one party is government, and that is why, to reduce the litigation, what many governments are doing, they are actually absolving their stake in the litigations. This is happening. So this is the alternative mechanism to settle this in Lok Adalat. Now, pecuniary jurisdiction. It means if a case is related to some money. For example, you are in contract and you were bound to pay someone, but you have not paid. So that would be pecuniary jurisdiction if such matter is being discussed. Permanent Lok Adalat shall be up to 10 lakh rupees. Matter can be discussed in this. However, the central government may increase this. How means of how much money cases can be taken up in this permanent Lok Adalat. Now, before dispute is brought before any court, any party of the dispute make an application to the permanent Lok Adalat for settlement of dispute. After the application is made to the permanent Lok Adalat, no party that application shall invoke jurisdiction of any court in the same dispute. So it means once it is filed in permanent Lok Adalat, then you cannot simultaneously file a case on the same dispute in any other court. Don't waste the time of any other court if you have filed a case in permanent Lok Adalat. Then we have family court. Why they are called family court? Because there are so many cases related to family disputes. For example, divorce, separation, marriage issues, alimony. So Family Court Act 1984 was enacted to provide establishment of family court. Now, status of family court, is it an executive, constitution, statutory? Statutory, because there is a law, parliamentary law for that. Marriage and family affairs. Now, reasons. So 59th report of Law Commission suggested that stressed that dealing with the disputes concerning the family, the court adopt an approach radically different from the adopting ordinary civil proceedings. Because if there is a matter related to tax, fraud, those are different nature, and family disputes are of different nature. So why you are using same judicial methods, right? Many family disputes can be resolved through mediation purpose, right? Give some chance for second thought without engaging into legalities. That is why this family court as an institution was established for speedy trial and having less burden. The Code of Civil Procedure was amended 1976 to provide for a special procedure to be adopted in suits and proceedings related to matters concerning family. Because within family also there can be a a dispute related to land, right? Money, right? This is the major dispute. So these disputes come under civil procedure. So this civil procedure was amended so that alternative judicial process can be used for these matters, family matters. Now, main objective and reason for settling family courts, to create specialized court. One thing is that exclusively deal with family matters instead of mechanism for conciliation. As I told you, sometimes methods can be disputes can be resolved through mediation, giving second thought. Inexpensive remedy, it is flexibility and informal atmosphere. This is needed for the resolution of dispute. Features are family court by state government in consultation with High Court judges. Now, state government word is used. Okay, state government constituting family court in consultation with High Court. It makes obligatory on state governments to set up a family court in every city or town with a population exceeding 1 million, more than 10 lakh population. It provides only one right of appeal and shall lie on the level of High Court. Means there can be one appeal, and that is at the level of High Court. This can also be a scope of question. Now, it exclusively provides jurisdiction of the family courts matters related to property of spouses, legitimacy of any person, guardianship, maintenance of wife, children, parents, nullity of marriage, judicial separation, conjugal rights. So these are the family matters. Now we have Gram Nyayalas. Gram Nyayalas, as the name suggests, Nyayalas at the level of Gram, right? Now, in some areas, we have districts having more than 700 villages, yes, in one district, right? And it is very expensive for a person from a village to come to the district or even subdivision for a case hearing, right? And that is why many actually, suffer exploitation, because they can't devote that much time and resources. So that is why we invented this concept of Gram Nyayalas. It is like justice at your door, right? Now, Gram Nyayalas Act 2008 has been enacted to provide for the establishment of Gram Nyayalas. It means it's a statutory body, grassroots level, for the providing access to justice of citizens of their doorstep. As I told you, justice at doorstep. Ensure opportunities for securing justice, not denied citizen, socio-economic and other disabilities. If someone is not having money or any other factor, that person should not be limited from the justice. Now, they are appointed by state government in consultation with High Court. Two courts I have told you having same format when it comes to their constitution, means organizing them. That is family court as well as Gram Nyayalas, right? They have same process. Gram Nyayalas shall be established in every panchayat at intermediate level. It means block level. Gram Nyayalas shall be mobile court. It means it is not like going to be a brick mortar. Okay, it may be possible Gram Nyayalaya is being organized in a government school, then a dispensary, then some other government school. Okay. And please remember, both criminal and civil matters can be taken up at this level. So, halke mein nahi lene ka, right? You should not take it lightly. Both civil and criminal. Question can be asked from here. Gram Nyayalaya shall try to settle the dispute as far as possible, bringing about conciliation between the parties. Conciliation is also a way. Gram Nyayalaya shall not be bound by Evidence Act, Indian Evidence Act, and natural justice principle can be used. Appeal in criminal cases shall lie to the Court of Session. Court of Session means at the district level we are talking about, and shall be heard and disposed of within a period of 6 months. This is what it says, and this can be a question. Some students would think, sir, is there a law regarding this? If there is an appeal from Gram Nyayalaya at the district level, that matter should be disposed of in 6 months. Law says that, but does it happen really? That's a different story. Now, attempt these questions. With reference to Lok Adalats, which of the following statements are correct? Read each statement. Lok Adalats have the jurisdiction to settle the matters at pre-litigative stage and not those matters pending before any court. What do you think? Statement is true or false? It is false, because I have told you both ways, in both cases, pending as well as pre-litigation. Lok Adalats can deal with matters which are civil and not criminal. This is also wrong. I told you. Criminal also. Every Lok Adalat consists of either serving retired judicial officer only and not any other person. That is also wrong. I told you about social worker, advocate. So none of the statement is true. I think now it is clear to you. These kind of questions have been asked by UPSC. Composition also we discussed. District judge in a state are appointed by governor. We discussed it, right? And on the advice or consultation of High Court. Now, with reference to Gram Nyayalaya Act, which of the following are correct? As per Act, Gram Nyayalaya can hear only civil cases and not criminal cases. Tell me, is it correct or not? It is incorrect. We have just discussed both. Act allows local social activists as mediator, conciliator. That is correct. So it means only 2 is correct. Composition we discussed, or you can see here, right? The power of district collector as a district magistrate are maintaining law and order, control over police, to check passports of foreigners. Now the word is control land revenue. collect land revenue, or you can say adjudicate matters of land revenue, that could have been correct. But control land revenue, that is incorrect. So that is why A, B, C. Clear? Now, answer the following question by correct. You need to identify correct. According to appellate system, a person dissatisfied with the verdict given by the court of district judge could appeal on which of the following level? High Court. We discussed it, right? Specifically, the statement was there. Let's start with the basics. So, High Court were introduced in India by Britishers. For example, in Calcutta, Bombay, and then Madras. In our constitution, High Courts are mentioned in Part 6 of Indian Constitution. Okay, starting from Article 214 to 231. Original Constitution was saying there will be one High Court for one state, but after 7th Constitutional Amendment Act, now there can be one High Court for more than 2 states or UTs. It means one state, one UT. Now, can you tell me, can you give some examples of common High Courts in comments? So we have integrated judiciary, right? We have Supreme Court, then we have High Court. So today our focus is on High Court. Let's talk about some differences. There can be questions from here. When it comes to Supreme Court, decisions are binding on all courts. All courts means whether High Court or Subordinate Court, means District Court. Can transfer High Court judges? It means we are talking about collegium, in which CJI's role, means Chief Justice of India's role, and Senior Supreme Court Judge's role becomes important. Can call a case from lower court to itself, can transfer cases from one High Court to another. So these are the powers of Supreme Court. High Court considers appeal from lower court, appellate jurisdiction, we are going to talk about it today, has the power to issue fundamental right, means writs in fundamental right, Article 226, deals with cases within its state jurisdiction, means you cannot take up case from other state. What does it mean? If some crime has happened in another state and district court of that state has given some judgment, can you take that particular case as an appeal? No, that particular state's High Court is going to take up that. Supervises and controls lower court. We are going to talk about supervisory jurisdiction of High Court here. District Court deals with local cases of the district, consider appeal regarding lower court decisions, decides serious crime cases. Subordinate Court deal with cases of civil and criminal nature. Now, appointment. So judges of High Court are appointed by President. Please remember that. They are not appointed by Governor. Sometimes UPSC play along these lines. Chief Justice is appointed by President after consultation with CJI and the Governor of the state. Although we are going to talk about third judge's case here, then you are going to remember the collegium part. For appointment of other judges, Chief Justice means Chief Justice of that High Court need to be consulted. Okay, that's a standard rule you should remember. Okay, for example, if you are a team manager and someone need to be appointed in your team, so this is a standard practice now. You are going to be consulted, because any judge of a High Court has to work in close coordination with the CJ of that High Court, Chief Justice of the High Court. Chief Justice of High Court is going to decide which kind of cases, what case is going to be taken up by this particular judge, okay, this particular bench. In case of common High Court of 2 or more states, the governors of all states concerned are consulted by the President. In second judge's case, Supreme Court ruled that no appointment of judge of the High Court can be made unless it is in conformity with the opinion of Chief Justice of India. Then it was later elaborated, third judge's case, collegium. Supreme Court opined that in case of appointment of High Court judges, the Chief Justice of India should consult a collegium of 2 senior most judges of Supreme Court. This is what third judge's case was saying in 1998. It means 1 CJI and 2 senior most judges. The sole opinion of CJI is not going to be considered, right? Consultation means you have to consult 2 senior most judges in case of appointment of High Court judges. Okay, there can be a question from here. 99th Constitutional Amendment came, and there was a body, NJAC, which government tried to make, National Judicial Appointment Commission. We discussed this in Supreme Court chapter also. But what happened? In 4th judge's case 2015, Supreme Court has declared both the 99th Constitutional Amendment Act, which was creating NJAC, as well as NJAC Act as unconstitutional and void. Why? Because Supreme Court said it is going to compromise independence of Supreme Court, independence of judiciary, and independence of judiciary is basic structure, right? Earlier, the collegium system became operative again. So this was an attempt. 99th Constitutional Amendment Act was an attempt to replace collegium system. And why? The reason was that collegium was or is opaque body, opaque mechanism. Lack of transparency is there. Qualification. You need to be citizen of India, obviously. He should have a judicial office in the territory of India for 10 years. Or he should have been advocate of a high court or high courts in succession for 10 years. These are OR's part. Okay. Either you can have this combination or you can have this combination. Oath is given by governor. Please remember, appointment is being done by president, but oath is being given by governor. Tenure, there is no fixed tenure. Okay. But what is age? Age, maximum age is 62 years. Now there can be a question from here. What if we have some discussion on the age of that concerned judge of high court or a person who is going to be appointed as judge of high court? In this case, any question regarding his age to be decided by president after consultation with Chief Justice of India. And the decision of the president is final. It means UPSC can play with you by saying, in case of confusion or dispute with respect to age of a concerned candidate for the position of judge of high court, Supreme Court's decision will be final or Supreme Court will take this up. But reality is president. Okay. And it is saying president is going to consult CGI. Okay. It's not like a formal case is going to be leveled regarding this. He can resign his office by writing to the president. Now, oath was given by governor. Okay. But resignation is being given to president because president is the one who appointed. What UPSC is going to play with you? They are going to use CJ of High Court. And many students would think, oh, since High Court judge and senior of High Court judge is Chief Justice of High Court, it means he or she should give resignation to Chief Justice. But that's not true. That is going to be a trap. He can be removed from office by the president on the recommendation of parliament. There's a process to that we are going to discuss. He vacates his office, judge of Supreme Court, or means the way Supreme Court judges are removed is the same way for removal of High Court judges. Removal of judges. So process of removal is elaborated in Judges Inquiry Act 1968. For that, a removal motion signed by 100 members in case of Lok Sabha and 50 members in case of Rajya Sabha. We discussed the same in case of removal of Supreme Court judges. Same is the process. Then they are going to present this before Speaker in case of Lok Sabha, Chairman in case of Rajya Sabha. Now, Speaker or Chairman may admit it or may decline it. If they admit, then there are going to be an inquiry committee and 3-member inquiry committee. And who is going to be part of this inquiry committee? There can be a question. Chief Justice of India or Judge of Supreme Court. Chief Justice of India or Judge of Supreme Court. What UPSC is going to play with you, they can use the word Chief Justice or Senior Most Judge of Supreme Court. But senior most judge is not there, or judge of Supreme Court. And some of you might say, sir, why you are playing on these intricacies? Yes, because there's a logic behind it. Why the word senior was not used here? Because same kind of setup is used when we talk about removal of Supreme Court judge. Okay, and consider a Supreme Court judge is quite close to the senior most judge or CGI. Now, in this case, don't you think this will be a conflict of interest if everyone knows that they are related, right? Or they have some common link. So on this basis, that particular person, CJI would say, okay, I am not going to be part of inquiry committee since I have common connection. Senior most judge would say, okay, I am having common connection. So that is why the scope was judge of Supreme Court, so that other judge can actually take up this responsibility. Okay. A Chief Justice of High Court or distinguished jurist. So you need to remember one person from Supreme Court, either CJI or Judge of Supreme Court. Second is Chief Justice of that High Court, Chief Justice of High Court, and distinguished jurist, Chief Justice of High Court. Okay, not necessarily that High Court. That is also need to be remembered. Please remember. If committee finds the judge guilty of misbehavior, now tell me, if committee found, yes, this person has committed this particular misbehavior. Now tell me, the decision of this committee is going to be final on this house, that now it is mandatory that person is going to be removed from judge of High Court position, or it is not mandatory? Answer is not mandatory. Because if it is mandatory, then why would you have voting by special majority? Then there's no point of having voting if it is mandatory just after the recommendation of this 3-member committee, right? You should think on these depth. After the motion is passed by each house by special majority, then it is presented before Honorable President, and when President signs, it stands removed. The President passes an order for removing the judge. Clear? Now transfer of judges. So President can transfer a judge from one high court to another. Okay, President is appointing, President is transferring high court judges. Please remember. In third judge's case, 1998, Supreme Court opened that in case of transfer of high court judges, Chief Justice of India should consult, in addition to collegium of 4 senior most judges of the Supreme Court, Chief Justice of the 2 high courts. What does it mean? It means Chief Justice of India along with 4 senior most judges is going to consult 2 high court judges, high court chief justices. Who? One from where you are transferring this high court judge, and other chief justice should be in whose high court you are transferring this judge. Okay, so it means 4 plus 1 5 and 2 7. Clear? Acting chief justice. So President can appoint a judge as acting chief justice. So what is the meaning of acting? It means present chief justice is not in position to work. Office of Chief Justice of the High Court is vacant. Chief Justice of the High Court is temporarily absent. Chief Justice of High Court is unable to perform his duties. So President can appoint qualified person as additional judges of a High Court or a temporary period not exceeding 2 years. So not exceeding 2 years is also a clause there. Now independence of High Court means, do we have some provisions which shows that yes, independence is maintained? Yes. For example, mode of appointment, collegium system is there, right? Security of tenure, 62 years, right? And you can be removed only by a process of parliament. Please remember, removal of high court judge cannot be done by state legislature or state government. Okay, CM, MLAs, they don't have any role. Clear? Fixed service conditions, expenses charged on consulate fund, charged. It means they are not going to take up for vote again and again in the budget. Conduct of judges cannot be discussed in the house until and unless there is a removal motion in place. Power to punish for its contempt. Its jurisdiction cannot be curtailed. You cannot curtail the power. Freedom to appoint staff. For example, State Public Service Commission work in close coordination with State High Court when it comes to staff hiring. Separation from executive, ban on practice after retirement, means judges cannot practice as a lawyer in court after retirement. Now coming to the other important part, jurisdictions. Now recollect what we discussed in original jurisdiction. What does it mean? It means that in these areas, a person can directly go to this level of court, right? So original jurisdiction, power of High Court to hear disputes in first instance. Not way of appeal, means cases which can directly go at the level of High Court, then these cases or these areas will come under original jurisdiction of High Court. Okay, it extends to what kind of matters? For example, will, marriage, divorce, company law, contempt court, dispute relating to election of members of parliament, state legislature. Please remember, members of parliament, right? Dispute related to this also comes under original jurisdiction of High Court. There can be a question. Revenue matter, fundamental rights, for example, Article 226. You can directly go to High Court. Cases to be transferred from subordinate court involving interpretation of constitution, means interpretation of constitution. You know, there are just 2 levels of judiciary, higher judiciary, you can say, High Court and Supreme Court, who can interpret constitution, right? So these are original jurisdiction. Now writ jurisdiction. We discussed these writs when we discussed Article 32, the meaning of these writs. And I told you there that as per Article 226, High Court can issue these writs for protection of fundamental right as well as legal rights. But when it comes to Supreme Court, under Article 32, Supreme Court can issue these writs just for fundamental rights. Okay. So this is what we have discussed here. So writ jurisdiction of the High Court is wider. Okay, because it also includes protection of legal rights. Okay, I hope it is clear to you now. Now in Chandra Kumar case, Supreme Court said writ jurisdiction of Supreme Court as well as High Court are part of basic structure of Indian Constitution. So please remember the case as well. Chandra Kumar, writ jurisdiction. Okay, for that you should remember, make some mnemonic. Logic means your own logic, a story, because these are the high probability questions. Now appellate jurisdiction, it simply means by way of appeal you can reach to High Court. For example, primary court of appeal is High Court, means High Court works as primarily as court of appeal, because from subordinate court, district court, matters take up at High Court for appeal. It hears appeals against the judgments of subordinate court in its territorial jurisdiction. Means if there is a UP High Court, it is not going to take up appeal from district court of Madhya Pradesh, right? It has appellate jurisdiction in both civil and criminal matter. Hence the appellate jurisdiction of High Court is wider than the original jurisdiction. Now civil matters means we are talking about matters related to land disputes, matters related to tax revenue, family disputes. So first appeal from the orders and judgments of district courts, they can come as appeal before High Court if the amount exceeds a stipulated limit. Second appeal from the orders and judgments of the district court when there is a question of law, means you need interpretation from High Court on this particular law. So it means both the cases, whether it is amount, whether it is about interpretation of that particular law, these cases can come at the level of High Court as a way of appeal. Calcutta, Bombay, Madras High Courts have provisions of intra-court appeal. Please remember it. First of all, what is intra-court appeal? It means your case was taken up at the level of Calcutta High Court. Okay, judgment has been given, but you're not satisfied. So you should not necessarily think about Supreme Court. You can actually go for appeal within Calcutta High Court. This is called intra-court appeal. Means within court you can appeal. Okay. Appeal from decisions of the administrative and other tribunals lie to the divisional bench of State High Court. It means from tribunals as well. Appellate jurisdiction of High Court extends there. In 1997, Supreme Court said that tribunals are subjected to writ jurisdiction of High Court. Means High Court can issue writs against tribunals. Consequently, it is not possible for the aggrieved person to approach Supreme Court directly against a decision of the tribunal. Now my question to you here is, can you tell me what about appeal against a award or judgment of water dispute tribunal, interstate water dispute tribunal? So you have to answer this in comments. I'm simply asking, this particular statement is saying when it comes to decision of a tribunal, you cannot directly go to Supreme Court. First you have to go to High Court. I'm asking, can this case or this particular notion be applied for the case of interstate water dispute tribunal? Okay, so think about it. Water dispute tribunal, search about it, let me know in comments, because these are the areas where UPSC is going to play. Now, criminal matters, appeals from judgments of Sessions Court, Additional Session Court lie in the High Court if sentences of imprisonment are more than 7 years. You simply need to remember two things when it comes to appeal in case of High Court. Number one is 7 years and more. If sentence is 7 years or more, then it can be taken up at the level of High Court as appeal, right? Second is, in case of death sentence by a district court, district session court, no matter that person has appealed before High Court or not, High Court is going to take up this matter because it is about death sentence. Okay, death sentence cannot be executed without High Court taking up this matter. So in death sentence, please remember, in some cases specified in various provisions, Criminal Procedure Code, the appeal from the judgments of the Assistant Sessions Judge, Metropolitan Magistrate and other magistrate judicial to the High Court. Means in certain cases they can directly go up as appeal to High Court. Now comes the supervisory jurisdiction. What does it mean? Supervising. What is the meaning of supervising? It means you are taking care of the rules and whether they are being followed on regular basis in these lower courts, right? So it means High Court has the supervisory jurisdiction over district court, subordinate court, not Supreme Court. Supreme Court is not having supervisory jurisdiction. Some students are going to get confused. Like it is said that judgment of Supreme Court is applicable on all courts. Judgment is one thing, but when it comes to supervision, it has two components, administrative as well as judicial. Means staff related function, and these functions, general rule, prescribed forms, book entries, accounts, how many court fees you are taking, in what way you are taking. These matters are also under the control of High Court of that particular state. The power of superintendence of High Court, it extends to all courts, tribunals, whether they are subject to the appellate jurisdiction of High Court or not. This question can be asked. Means supervisory jurisdiction is applicable on all tribunals in territorial jurisdiction of that High Court. Okay. It covers not only administrative superintendence as well as judicial. Means the kind of decisions you are taking, the speed with which you are actually taking up the cases. So judicial part is also going to be considered here. Revisional jurisdiction means judgment can be revised, right? It can also take suo motu action, means on its own. However, the power does not vest in the High Court with any unlimited authority over the subordinate courts and tribunal. It is limited to access of jurisdiction, means in what cases High Court can intervene in the functioning of subordinate court. If there is access of jurisdiction, it means you are not given that much power, but you are exercising power beyond your ambit. Then High Court can supervise. Gross violation of natural justice, error of law, disregard to the law of superior courts, means High Court has said something and High Court is a court of record, but you are not giving adherence to the what High Court has said on this particular matter. Perverse findings, manifest of injustice. So in these cases, High Court can intervene in functioning of subordinate court. Now, control over subordinate court, it is consulted by governor in the matters of appointment, posting. For example, I told you, in case of transfer, appointment, a State Public Service Commission is going to conduct the exam, interviews, but in close coordination with State High Court. And who is going to appoint? Their governor is going to appoint. I'm talking about subordinate courts. Okay. It deals with the matters of posting, promotion, grant, leave, transfer, discipline of the members of the judicial service of the state, other than district judges. It can withdraw a case pending in a subordinate court if it involves substantial question of law require interpretation. So because district court cannot interpret constitution, if it seems that interpretation is constitution is needed, then High Court can take up that case from district court. It can either dispose of the case or determine the question of law. Dispose means case is quashed, or it can take up the case. Law is binding on all subordinate courts because it is part of supervisory jurisdiction. When I say court of record, what does it mean? It means perpetual memory and testimony. In your judgments, you are going to quote this. These records are admitted to the evidential value and cannot be questioned when produced before any subordinate court. They are recognized as legal precedent, legal references. Means on this basis, you are going to do the judgment. It has power to punish the contempt of court either with simple imprisonment, fine, or both. Expression of contempt of court is not mentioned in our constitution. Please remember that. There can be a question from here. We have a law, Contempt of Court Act 1971, which elaborate on the definition of contempt and what can happen. Under the contempt of court may be civil or criminal. Civil means willful disobedience to any judgment, order, writ, or other processes of the court, willful breach of any undertaking given to the court. That would be considered as civil contempt. Now, power of judicial review. We discussed in Supreme Court as well, right? Judicial review, Article 12, right? Article 13. Article 13 we talked about, and Article 32. So, judicial review is the power of High Court to examine constitutionality of the legal or executive actions. The phrase judicial review is nowhere mentioned in Indian Constitution, but Article 13 and Article 226 in case of High Court, it gives power to High Court to review whether legislative or executive action. Now, in what cases the judicial review can happen? One is fundamental right. If some law or some executive action is taking away your fundamental right, judicial review can actually work. Second is outside the purview. It means any authority has taken some action which is outside its power. How can this happen? Judicial review can apply. Or these provisions or these laws which are being made or some executive action, this is against some constitutional provision. In this case also, direct judicial review can be applied. So these three are the areas which you should remember when judicial review is going to be applied. Direct question can be asked. So during Indira Gandhiji's time, 42nd Amendment Act, it actually limited the power of judicial review of High Court, saying that judicial review is going to be applicable just to state laws, right? But after this 43rd Amendment Act, it restored the original position. What does it mean? There can be a question. Meaning is that judicial review power of High Court is applicable also on central law. Please remember it. Now, which of the following is the oldest High Court in India? Calcutta High Court? That's a factual question. Now, Article 203 provides that there shall be a High Court for each state. Tell me, do you think that statement is true? Now, some of you might be thinking, sir, we don't remember the articles. What now? My friends, sometimes some articles are regularly in news and UPSC wants to check whether you are aware about them or not. It's not like UPSC wants you to cram the whole constitution article wise. Article 213 is related to ordinance making power of governor, right? And Article 123 is about ordinance making power of president, right? So how can this statement be true then? It's false. Now, judges of High Court are appointed by president. You just got to know. Under Article 226, it has the power to issue certain writs. We discussed it. As per provisions of the Constitution of India, common High Court can be established for 2 or more states. It is right. By which Constitutional Amendment Act? We discussed 7th. Right? So answer would be 234. C. Right? So I hope now this part is clear to you. See you in the next video. Till then, keep learning, keep growing. If you find any question which is troubling you, you can shoot me a message on my personal Insta, shashank.powerbeing. I'll be more than happy to help you out. This PDF is going to be available in Shashank Tyagi For You Telegram group. See you.